क्यों नहीं मेरे यार देखे नहीं
But, Mr.
at long
Bhatta,
last you have come to
but just one
grace
day
that
when I was there every day. One day I was there.
yes
Lord, Mr. Bachawat was making his submissions. He's coming, Lord. I'll just start in the meantime.
absolutely
Now, Lord, if your lordship picks up.
My lord, under complete circumstance, I am coming before your lordship.
this appellate side or original side
Appellate side, my lord.
please mention when you take up the appellate side matters my officers will be there, it will be easier
After original side.
after original side, please. No, three till 3 today because I don't have appellate side matters too many.
2 p.m., my lord.
3 p.m. or if this list falls, then we'll take up the meeting. No difficulty, come whenever. Just keep a watch when the last matter is over, then come. Yes.
Yes, Lord. Lord, if your lordship takes up the petition and the supplementary affidavit, my lord, on the principal case that they initially sought to run
Yes.
was there is nothing on record to show that there was any arbitration.
Sorry, Mr. Kosh, you are for which respondent? Just tell us.
My lord, I am for the respondent. There's one
Oh,
respondent.
there's one. Right. Yes, please carry on.
Now, my lord, they come before this court in the section 34 petition. Their first statement, which was before this court, was that there is nothing on record to show that there was any initiation or any arbitration which was there. So, in effect, that the award is absolutely a wish-wash and couldn't have been there at all. But after filing of the petition, when my lord, when they were moving this, they came up with a supplementary affidavit as well. Now, in the supplementary affidavit, they have run a case which is not contrary, but to the effect that their petition case is perhaps not correct entirely. Insofar as they disclose certain documents, which is in the nature of, my lord, proceedings in section 9, and, my lord, also the fact that there was something which has happened. The section 9 proceeding is, my lord, if it's not the arbitral reference, but it is an initiation of a proceeding under the statute, which, my lord, also entails, my lord, the intention of the parties, if not the parties, at least the claimant, which is, my lord, the petition before lordship, to have the disputes adjudicated by way of arbitration. My lord, section 9, if your lordships have a look.
Yes, before, during, or after, and 2.
No, it is
They have to go there.
what is the purpose, my lord? Only because before, during, or after, it's of course with regards to, my lord,
Also, the
maintainability.
Subsection
It
2
is
2 is there also.
yes, my lord. My lord, if your lordship sees, one is, my lord, that we'll skip over. 2, for interim measure of protection in respect of any of the following matters, namely preservation, custody, sale of goods, which are the subject matter of the arbitration.
Yes, yes.
So, my lord, it is filed with an intent that, my lord, the asset which has been financed should be preserved, or, my lord, should be secured, or should be returned. Now, my lord, what they proceed to do is this. Lord, when we come up with this case that the asset was in fact returned, there is nothing on record to show that they have at any material point of time either attempted to find out what was the actual position, where is the asset, and what is the consequence which is followed. They have only stated that there was nothing which had happened. And in fact, if I'm not mistaken, in the course of their submissions, they have made this statement that there was nothing which was returned, and the valuation report was by us, which again is, my lord, incorrect. My lord, I'll place the valuation report, and lordship kindly have a look at it. Reply to supplement. Watch it.
Opposition.
So this is in reply, my lord, in the opposition, my lord, I'm sorry, my lord, in the opposition to the section 34, So this is affirmed on 30th of July, 2024. If your lordship is pleased to turn to page 33.
এটা নয় 33 পর্যন্ত নেই
The 30th of July, 2024.
30 July it is.
Well, in AP 529, my lord. Lordship has that.
No, 5:30.
You submit.
No difficulty. Yes, 30.
Yes, my lord. Lordship, page 33 is, my lord, a report of the surveyor and valuer. Lordship will kindly take note of the reference number. It refers to Shrey. RW1/Shrey/2020.
At the top also.
Right on the top. Yes, my lord, as well on the top. This is, my lord, 8th of March, 2020. My lord, particulars of, my lord, the asset is specified. And, my lord, turning over to the next page. Kindly sees, my lord, this is the repossession memo.
Next page.
Is page 34.
Sorry, yes.
At page 34, it is on, my lord, a printed form of Shrey. Right at the head, my lord, it's Shrey Equipment Finance Limited, inventory list of repossessed assets, vehicles, machines.
Yes.
Now, the particulars of the asset is there. And, my lord, lordship can kindly have a look at how we have brought this document on record. This is at paragraph 12.
Mr. Ghosh, what are you trying to
My lord, because
show? Yes.
to the extent that, my lord,
Yes.
they have, if I'm not mistaken, my lord, their primary cases, this entire arbitration
Yes.
is, my lord, a wish-wash arbitration. Perhaps there was nothing which has happened. That is their primary case. And the award which has been passed, it's a fraudulent award. Now, my lord, whatever their case is, they've taken it to a state where, my lord, it's a very high case to run, if I'm not mistaken. Now, if, my lord, that is the case they have run, they also have an obligation to establish that all of this, what has happened, which is, my lord, ancillary or in aid of arbitration, should not also exist. Whatever has happened in aid of arbitration, well, once you initiate an arbitral proceeding, my lord, it can be by way of a section 9, can be by way of a section 21 notice, can be by way of various other proceedings.
But there is nothing in depicted in this document to show that it was connected with any arbitration proceeding.
No, my lord, because the section 9, my lord, it is our case, my lord, that it was withdrawn because it is recorded in the order that we will be returning. That was the basis.
Yes.
Now, if I have not returned, say, my lord, taking it their case to be, if it's taken to be true, if I have not returned, what would have happened? Well, merely withdrawal of section 9 wouldn't have happened. Then it would have, consequential follow-up would have been a section 21 notice, which again would have been followed up with an arbitral reference. So, my lord, why this is important, I also indicated the date, my lord, 8th March 2020. This is after, my lord, after the notice of 21. And, my lord, we accepted, my lord, the reference in December 2019. So naturally, my lord, it is evident that something must have transpired, which ultimately resulted in us handing over the asset. Because, my lord, there was a 21 notice, which was followed by our acceptance. It may be belated acceptance. There's no limitation against it.
All right.
So, my lord, in aid of the arbitral reference, my lord, the valuation happened. In aid of the arbitral reference, I did hand over the vehicle and it was repossessed. It is their document. Lordship will kindly see how they have dealt with it. I'll place the paragraph where I have annexed this document in my opposition. Well, paragraph 14, page 5.
Yes.
Well, from about somewhere middle of the page, my lord, at paragraph 14, the receipt of the stacker. Lordship has that. The receipt of the stacker is admitted and recorded in the inventory report prepared by the petitioner, copy whereof is annexed here to marked as annexure A. The petitioner received the stacker from the respondent on March 9, 2020. The receipt of the stacker is recorded in the letter of the respondent. The equipment was valued at 75 lakhs. Report of the chartered engineer and valuer appointed by the petitioner in this regard is annexed here to marked as annexure B. This is, my lord, what we have stated. Now, Lordship will kindly have a look at how they have dealt with it, which is at page 9, paragraph 9.
Reply
In the reply.
529
Well, this was affirmed on
530.
14th of August, 2024.
529.
Yes.
Well, in 530, vehicle valuation.
No, it's not. You're right. এটা আপাতত সরিয়ে রাখো যেহেতু এটাই করছি 529
The paragraph 9. Reply paragraph.
Yes, para 9.
Yes, Lord. Paragraph 9, my lord. It starts at page 9. Lordship will, if your lordship is pleased to kindly turn over to the next page. In fact, my lord, from the last page, word of page 9, I, turning over to the next page, my lord, deny the veracity, validity, legality, and enforceability of the letter in March 11, 2020, and also the valuation report for the alleged equipment. I deny that the petitioner received the stacker from the respondent on March 9, 2020 as alleged or at all. I deny that the equipment was valued at rupees 75 lakhs as alleged or at all. Bare denial. It is their document. It is, they don't deny, my lord, that it is, this inventory list is their document. They just deny the valuation. And my lord, lordship will kindly take a look at how they have affirmed this. Para 9 is, my lord, the affirmation is at page 20, paragraph 17. Shouldn't be numbered. 7 to 15 based on records. There is record, they deny it. That is all. They do not for once say as to why, my lord, they can, or there are other records to show that the equipment was not received. They have merely denied that there was return of equipment. And that they say is based on record, but no record to substantiate this statement.
But what could they show? They cannot prove a negative fact because their case is that they were not there in management at that point of time.
Now, my lord, if they say that they were not in management and if they're relying on record, it is also their obligation to call upon, my lord, the management which was in place.
That is there. That is always there.
They
That
ought
argument
to
is
have.
there.
They ought to have called upon them. It is that argument is, my lord, has been made, my lord.
My point is that suppose even if they had knowledge, I mean, you say something that this is on record, and they say they deny it. Then what records? Negative proof cannot.
Yes, my lord. If it would have been my
If I
document.
say it's not on record, I mean,
Yes, my lord.
I'm not required to produce any record.
No, they can deny that it's not on record, but at the same time, my lord, it's not one document which is being denied. It is, my lord, an equipment which is
Some explanation ought to have been there.
Yes, there has to be an explanation as to why
How did this came about?
Or, my lord, it is an asset. End of the day, it is an asset which they own. Now, if that asset is not there, they must be having an inventory of the assets that they have. They have never produced an inventory to show that they've never received back this particular asset. It's not, my lord, a small asset. It's a stacker, my lord.
If they didn't receive back, they won't have any document.
No, but my lord, yes, my lord, that is exactly the issue, my lord. In their, my lord, management information system, they would be having all the equipments that they have repossessed.
Something to show that it was not
Yes.
Contemporaneous something.
Yes.
Very good.
Or in the alternative, my lord, if they are going by the plan, it would have been reflected in the IBBI website. It would have been reflected as an asset, my lord, because, my lord, when a plan is to be sanctioned, before that, there has to be an IBBI information memorandum which is submitted. The information memorandum would show that it's not there. Yes. And my lord, one more thing, my lord, lordship sees paragraph 9 once more, where they have dealt with it.
You reply in the original petition.
Yes, my lord. They are denying receipt and they are denying, my lord, the valuation.
Hmm.
But, my lord, the fact that there was a valuation report, they are not denying. And they are not denying, my lord, that this document does exist. Or, my lord, that the person concerned was employed by them. Well, in the course of their submissions, my lord, they have stated, my lord, that the two persons who have received the documents, one is, my lord, the document which we served the award, and, my lord, the person who issued the notice under section 21. These persons were on notice. Well, if these persons were on notice, and, my lord, if it is their case that they have issued these documents without authority, or they have received a document and the award without authority, my lord, the logical conclusion to that would be that they were also parties to this fraud which they are alleging. They have not disclosed anything to show that these persons have been implicated in any proceeding apropos, my lord, this alleged fraud that has been perpetrated. Not one document on record to show, yes, my lord, to show that either the person who has issued the notice under section 21, or, my lord, the document issued by a certain who has received it, the award, there has been any initiation of any form of action against them. My lord, specifically the person who received the award. Lordship will recall, my lord, when I was making my submissions on the application, the date on which he has received it, and, my lord, the internal email which they have disclosed in their opposition, which says that these persons were on notice. There is a gap of around 10 months. So naturally, a notice period is not of 10 months. They must have initiated disciplinary proceedings against them. If not, my lord, criminal investigation. Then may I have your lordship?
Yes.
But I must apologize not
No,
for
no.
being late in a part-heard matter. Not something pressing came up at home. My fault, not completely. Not before, not. I'm sorry, not. I'll just digress from where he was arguing on. Not on the last day, not a interesting spin came in the matter. Not two questions which your lordship had put.
Yes.
So, not I thought, not I'll first address this point of law, and it's an interesting not point. Not I'll take care of it, and then not whatever little loose points are left, not
Yes.
we'll deal with that. So, not if your lordship would not once take section 34. Now, but I had made a statement that day that the object of the amendments not is to restrict as opposed to expanding. But I wasn't not really sure of the legal position, not that. But it seems very clearly now, not, and I'll show your lordship not how courts have approached it, that the object of not bringing 34(2)(a) and those amendments were to restrict. But the more interesting thing comes up is that, well, there may also have been a little not mistake in framing this not legislation, which is why not I thought this is not a interesting point. Now, not if your lordship takes not 34, not as I see it, not if I may just preface my not submission on 34 with just one or two comments. Not 34(2)(a) has come in subsequently.
Yes.
34(1) is prefaced by not every not application for challenge must be made in accordance with 1 and 2. Now,
2 and
whether-
3. I mean,
not, I'm sorry, not 2 and 3.
obviously, yes.
Now, the question is not when 2A comes in between, would it include 2A also or not now?
Obviously, it is.
Should.
Sure.
And
that
not
should
the-
have been amended.
And not, I had not known that not there's a, well, the Law Commission had not actually taken note of that fact.
Oh,
Not, I had not realized it, and we were just discussing it. And I said that look,
obviously.
2A actually should have been, 2 capital A should actually have been, according to me, not a subsection
Exactly.
of 2. It should have been. Because not there's other things to bear it out. If your lordship looks at it, not 2 provides the grounds
Exactly.
for
Right.
setting aside an award. So does 2A. 2A is just an additional ground. Whereas 3 is a procedural thing.
That language is also somewhat peculiar. In accordance with, how can it be in accordance with? In accordance with 3, probably both were covered. The time period and the grounds both were covered by a single sentence
Possibly.
for economy, probably.
Possibly. Now, my lord, if 2A is to be read as part of 34(1), not that not subsection 2 and 3 will include 2A, but then
Has to, otherwise 2A has no meaning.
absolutely 2A will become meaningless.
Meaningless.
So, my lord, if 2A is read into it, then, my lord, recourse to an award against an arbitral award may be made only by an application by setting aside such a award in accordance with 2A 3. But if 2A is read to be a part of 2, then it must be in accordance with 2A also. Now, given that, now, my lord, please see section 34 2B.
Yes.
2A is party making the application. The distinction we were drawing was 2A is where the party furnishes, and 2B was giving the court the power to do it on its own.
Yes.
Now, my lord, your lordship will find the court finds is over there also. And, my lord, capital 2A also includes that same language.
Yeah.
So, my lord, the implication would be, my lord, perhaps that 2A is really, 2 capital A is really part of 2. Now, if that be so, then the award can be only, my lord, set aside on an application made under 2A. So it can't be the court making up its own grounds, if I may put it this way. It must be in the application. The court can't on its own suo moto, my lord, say that, look, I'm finding a new fact. The grounds must be there. The grounds under 2 and 2A must be there. But this is not really the argument I'm going to make, and I'll try and not bear it up with
So,
some.
Bacha, this is distinction. I'm just opening up.
Well,
Now, ground has to be there in the application, even in case of 2B or 2 capital A. Ground has to be there in the application. But the question is how far they have to establish. Because if they don't have to establish,
that's a question of fact. No, let's leave that apart. Let's just look at
the
it.
owners also. I mean, owners, in fact, they have
Correct.
to bring to the notice of the court.
Absolutely.
And then the court does whatever it has to do on the basis of the records. Then much more leeway is given to the court. Order 6 Rule 4 analogy cannot be drawn strictly.
Correct. No, that's the reasonable interpretation. But the two Supreme Court, or rather the Delhi High Court judgment and the Supreme Court judgment that they have not showed, seem to say that the court can suo moto do it of its own without anything being there.
Maybe going a bit too far.
Correct.
In view of language of
That's
one,
all that I was trying
subsection
to.
1.
That's all I was trying to not.
Ground
bring
has
down.
to be there in the
No,
application.
they said it can be brought in by way of an amendment and at the
that,
appellate
okay.
stage. And at the appellate stage. At the appellate stage.
Mr. Bachawat, does a ground is a part of the application, right? I mean, and after amendment, it is to be read into the application. Now, can a ground be independently treated as an application? And I file an application. I have to file the application within time. But I don't have to take the grounds within the limitation period. I mean, I file an application.
I appreciate.
Maybe one of the views, and your view is also another valid view. I mean, we have to choose between one.
Let's also not look at this situation. But would grounds include foundational facts? Let's put it this way: the foundational facts.
All right. Yes. All right. Very.
But it's in that context. Not, I mean, it's an academic argument, but it's a.
That is also very valid. Your argument is also one of the valid perspectives.
But
Definitely.
the other part, not how much of grounds to be shown, other things, those are settled. Not fraud, one must establish beyond reasonable doubt. There must be enough material, etc., etc. Not verification, etc.
Even
Enough
if
evidence.
they don't establish, court has to be satisfied beyond reasonable doubt. You can argue that.
But
Definitely.
there also there's an interesting spin-off. In 36, your lordship will find
36,
the language used is court is satisfied.
Yes.
And here it is court finds, which shows it's a higher level of proof. I tell your lordship why. 36 is the stage of furnishing security.
That
So,
is 2.
36.3.
Acha, oh, yes.
36.3 says that the court may say, don't give any security
Yes.
if the court is satisfied that there is fraud. Let me please see that language
Yes,
also.
I'll just.
Upon filing of an application under subsection 2 for stay of operation of the award, the court may, subject to such conditions as it may deem fit, grant stay of operation of such award for reasons to be recorded in writing. Now, my lord, provided that the court, while considering the application for grant
Second
of stay,
proviso. Yes.
correct, my lord, provided further, the court is satisfied that a prima facie case is made out, that the arbitration agreement or contract is the basis or the making of the award was induced by fraud, etc., etc. So, my lord, there also fraud is considered. There, the lordship will find, my lord, the language you use is court is satisfied prima facie. Satisfaction of the court.
Uses the expression prima
Prima
facie.
facie.
Also. Yes.
So this, my lord, this is on a higher footing, a finding.
Absolutely, has to be. You are setting aside the award.
Correct.
And there you are just granting an ad interim relief.
Correct. So it is more than not satisfaction of a prima facie nature.
Sure, there is no doubt that section 34 has to be on a much higher footing than this prima facie.
But the reason I said it, it's a little disturbing, but not prima facie satisfaction on fraud is a little odd. Fraud, one would have thought, is in any event on a higher footing.
Yes, but even in a suit challenging something on the ground
Absolutely.
of injunction, well, grant of injunction, you have to have a prima facie.
Absolutely.
Triable issue.
I agree. Not,
Yes.
I agree. Not there also, not again, please look at not the nature of the proceedings. That's also a factor. Is section 34 is heard on affidavits.
Yes.
So one is looking at affidavit evidence. So evidence on affidavit becomes very, very, very important because there is no later stage where one is going to call witnesses to prove things.
So the principles of writ jurisdiction versus suit comes in,
Absolutely.
where pleadings have to contain the evidence also, unlike a suit.
So, Lord, that's the reason, Lord, I say that the burden of proof required here is much, much higher. Lord, it will be exponentially high. And that is why, Lord, on the last day, we were trying to place those judgments on verification, the importance of verification,
Yes.
the proof. You can't just say submissions. Everything is submission. Fraud is also submission. And more important, no one to take responsibility. Particularly, not power attorney holder, not saying who he is, what his designation is. And more important, it would have been very easy for them to ask the old management. They've been writing letters galore to everyone, legal notices, not going to their advocate and everyone, all of that. Very simple thing was ask the old management, did you receive it or not?
So basically, Mr. Bachat, if I have understood you on that, is that one can very well play ostrich. I mean, come up and say that I can't see, I don't have records.
Correct.
And just that's why it's fraudulent.
But it's a better expression than the one I had thought of. My learned friends are using the IBC proceedings as a wall. It's opaque. When I want to, my hand can cross that wall, pick out what I want, bring it out. But for the purpose of the other side or the court, you can't see it, it's opaque.
And which wall is somewhat dented by their own conduct in the sense that initially they filed the application by saying these are all documents I have, and then they expand on that by producing further documents.
Correct.
That is also your condition. So then you have other documents up your sleeve. So you may have the award also.
Correct.
In a sense.
Correct. Particularly
That's
when
the
you
tenor
say,
of your argument. Yes.
particularly when you come to court saying that, look, these are all the records I have.
Yes. And the premise of your challenge is that there is no record.
Correct.
These are the records I have. Then you come up with further records.
Right.
So that you may have still further records. I mean,
the court cannot conclusively now determine, given these not factual, given these factual not situation,
Yes.
his case is not completely fallen flat. If I may
That the
put
court
it that
should rely on that and say that there is actually no award.
correct. There may be more over there.
And you have produced a copy of the award, not that there is no award at all.
Correct.
Then there would not be any challenge.
Absolutely. And Lord, if a lordship looks at the conduct, it's strange. Lord, if I was to challenge something on the ground that there was no arbitration proceeding, no Section 21 notice, no award, no asset return, Lord, what's the first thing I would do? In a situation like this, would I be writing, Lord, to my advocate, asking, hey, did you appear in the arbitration? Was there an arbitration? He writes, as per my records, there is no arbitration. Lord, one would first of all, tell the arbitrator, Lord, letters have gone to the arbitrator a number of times. Where is the allegation that there was no arbitral proceeding? My man did not attend. We never attended. This case is not made out in those notices. Forget the fact that he does not write to the erstwhile management.
But that letter to the arbitrator, Mr. Bachchat, may be a prelude to doing that. I mean, they ask the arbitrator, furnish whatever
Let's look
records
at
you
the
have.
time gap. Lord, let's look at the time gap. Let's look at the date on which he received the award and the date when he files the application. 120 days have gone by. Lord, that prelude can't come 2 days before you file the application.
All right.
He had 120, just about 120 days. Admittedly, he had that period.
Yes.
It's not that he discovered on the 120th day.
Unless we accept their point that that was not a proper service at all. I mean, the arbitrator has to. That is a different point.
Correct. I'll accept that. But if your case is you believe that there is no award, would you not write that?
Should have
And-
been a knee-jerk
And
reaction.
2 days later, file an application. Not 2 days later, an application is filed saying, look, the whole thing is fraud. But the first thing one would have done in this case is written to the administrator. First thing.
That is a very strong point. I mean, did
But
not write
take-
to administrator or their previous management. At least there is nothing on record to
No,
show.
not, I'll put it more strongly than that. I'll put it far more strongly than that. Not
Again, I think a learned genius.
the admiration for him is always heartfelt. No admiration.
No, no, but I
admiration is all one
Don't go by Mr. Mitra. He has admiration for everybody except himself. So don't go by his standards.
No, but
He's very
has some-
liberal in his admiration.
But I can't go by standards because those standards are very high, very high. I've seen this over not now.
Mr. Mitra is very liberal on bestowing this admiration and all these things. So he admires everybody except himself.
No,
maybe.
but he does set high standards. He bestows praise and confidence in juniors. He does that, but he sets very high standards for himself too. But it's one thing to make us feel good and say you've done a good job, knowing I've done a bad job.
Throughout my career, my lord, I relied very heavily upon the juniors because I always find that they come out with something new,
Yes.
something which I have not conceived of. They come out with.
And Mr. Mitra, unless you repose that confidence, it will never come out.
Right.
Not that reposing of confidence, I tell your lordship, extremely funny. I had just joined the profession and I had joined his chambers. I was going there and I would see one gentleman come in regularly to Mr. Mitra's chamber and he'd tell him, yes, we'll do it. So 2 or 3 months went by and it was a friend of Mr. Mitra. So one day I think he'd had enough of this gentleman troubling him. And I was brand new. I had probably 3 months in the profession. So when he came in, he called me in and he told his friend, he's studied from abroad. He knows everything about this area of law. There is no one better than him. You have found the best man in the High Court to do this. Go bother him. Salu Chaudhary, Guinness Book. Guinness Book. Guinness Book.
Oh,
He said my name should be entered in Guinness Book.
oh, that's that.
So this gentleman was dumped on me, and then I have never found a person with more perseverance and gung-ho than him. He felt he had been wronged. He ought to go. So he went and broke the world record because Guinness said that if you do it, put it in. Now, once it was in, they refused to put his name in. And they wanted the name out because apparently, according to him, he was an Indian. So they set up a British team to go and break that record. So the British team went and broke the record. So his name obviously couldn't come in. He was so determined. First time he had gone in a Contessa, and in that because of that he got frostbite and he lost partial use of a leg. He went a second time and he smashed that record. So not
He almost lost his leg
yes.
in the process.
So not very determined gentleman. Not fortunately, not I. Those were the days one would study. Not well, some studies done in law college. So not all these concepts of not tort and not contract were fresh in the head, and we did it, and we had a very successful not run.
Thanks to him.
Not to me. Not to me. That was
For giving the client.
so not. No, it's experience right from the
No,
beginning.
absolutely.
So that's why I said not. He had confidence in his juniors. But it was a long plaint which I had written, a very long plaint, and because we were told that plaints have to be 3 or 4 pages.
Yes.
And there was sudden urgency because they were about to release the book. So when I went to him, I said, this has to be now done. So not at night, he dictated the riders and we moved thereafter. And we got orders, upheld them in appeal and everywhere. Then contempt. So not this is the not long and short of it. Not I would say now I'll show your lordship not what the law commission said and what the not Supreme Court says after considering all these amendments, that the scope of these amendments is actually to narrow the scope of challenge as opposed to not expanding or giving additional grounds. In fact, this not the expression used in 34(2)(a), if your lordship sees, but I thought that it's bringing an additional ground.
Why not additional? May
Because
also.
not patent illegality was already actually a part of it.
Exactly. I don't understand with my
So it was
very
really
limited
to
knowledge of
limit.
this branch.
It was really to limit because by saying in the proviso that you cannot do it for this, that, and the other, not the judgments consider this aspect. I'll show your lordship.
Yes, yes.
On the face of the award. This
Correct.
was added.
Correct. So, my lord, I'll show your lordship the approach of the law commission and how my lord, courts have treated it. One judgment should be good enough for that, my lord, because there's only one judgment which really considers it in detail. Because, my lord, the strange thing is when your lordship sees the law commission came up with some recommendations, and those were about to be put in. They were about to be put in when another Supreme Court judgment came in, which changed the picture completely. So then, my lord, because of Western Gecko, my lord, my learned friend. So, my lord, then therefore, my lord, they had to come in with fresh new my lord, reports and things like that. So, my lord, this is the background of it. My lord, that should probably take care of this 34(2)(a). And then, my lord, given this, the last submission I'll make on it is, my lord, your lordships have already seen it. I won't repeat. 24(2)(b) already has that language court finds.
Yes.
Now, if a particular meaning is to be given in the context of 2b, then not the same meaning should be given to 34(2)(a). Because, my lord, according to me, even this 2b is to be read in lines with, my lord, 34(1), which is recourse to an arbitral award may be had only by an application for setting aside. It can't be some, my lord, completely new thing suo motu. Because the two judgments which he cites, my lord, seems to take it pretty far. So, my lord, before I deal with this academic part of it, my lord, may I just go back to those two judgments to show your lordship the width, and then, my lord, we'll finish off the rest. Lord, one was Devas, the Delhi High Court judgment. ওই Delhi High Court আপনি যেটা দেখালেন দিবাস ইকুইভ্যালেন্ট প্যারাটা দিতে
দাও
হবে
জাজমেন্ট দেওয়া দিয়েছে দেওয়া ছিল এটা ছাড়া আর কোনো নেই এই এটা ছাড়া আর কোনো নেই আরো আরো জাজমেন্ট দিয়েছেন
প্যারা 100 তোমাদের প্যারা 100
ওনাদের তো
ট্যালি করছিল না সো
বিরাট মোটা যায়।
হ্যাঁ ওটা অনেক মোটা জাজমেন্ট ডেফিনেটলি আছে দিয়েছে
এপ্রিল খুলে গেছিল।
oh same I thought no the court had a different one na court had this one
হ্যাঁ এইটাই।
একবার দেবেন ওই আমাদের ওই কপি আর ওই কপিটায় প্যারার নম্বরটা
ইয়েস ইয়েস
আবার সে হ্যাঁ
হ্যাঁ ওই প্রবলেমটা হয়েছিল না
দশটা এদিক ওদিক, 10টা প্যারা।
কোথায় গেল? The phrase, 110, 10, you're right. But I'm not going on the other part, not the explanation why, not in that case, there was already a Supreme Court judgment which the court ignored. So it was said that, look, Supreme Court has already said that there's fraud in the making of the agreement, in the making of everything. So it's something which should have been taken into consideration. There was not a award running into a few, not 100 million. Now, my lord, in that situation, my lord, please come to para 109.
Yes.
But in both cases, hopefully, my lord, it starts off like that.
Yes, it does.
And my lord, sorry, my lord, if your lordship would come to one para before that, only just to see, it's also noted the other judgment that they cited.
Yes.
Not state of Chhattisgarh, Saludyog.
Saludyog, yes.
Then, my lord, in both the cases, the apex court has looked into the language of the provision of section 34 of the Act and laid emphasis on the phrase the court finds that occurs in 34(2)(b) and 34(2)(a) of the Arbitration Act. This phrase has been interpreted by the court as an enabling provision, allowing courts, while deciding an application under Section 34, to grant leave to amend an application under Section 34 if the peculiar circumstances of a case so warrant. And I pointed out that there must be at least peculiar circumstances, and at least there must be an attempt to amend. Here, there is no attempt to amend anything. And if it is so required in the interest of justice, the court has held that the phrase enables the Section 34 to discover on its own patent illegality in the award and set it aside under 34(2)(a). So this is the part not which seems to be very, very wide. It has.
So it does not take into consideration subsection 1. That is your premise. One says it has to be in accordance. The application itself has to be in accordance with.
Correct. It has further been held that the provision which enables a court to act on its own in deciding an application under 34 would also be available to an appeal under 37. And Lord, in that situation, Lord, please see the next para also. The phrase
Yes, please.
The phrase the court finds, which finds mention in 34(2)(b) and section 34(2)(a) allows the court to look into the award and discover the grounds mentioned therein, mentioned under section 34(2)(b) and 34(2)(a) of the Act. So even if the grounds are not there, it can discover grounds. Consequently, the phrase enables the court to discover suo motu whether an award is in conflict with the public policy of India. As a corollary, having regard to the explanation 1.1 of 34(2)(b) of the Act, it follows that the court would also have the power to discover on its own whether the making of an award is induced or affected by fraud or corruption or as violation of 75 or 81 of the Arbitration Act. We therefore find no merit in the submission of the appellant herein. That is section 34. Court does not have the power to suo motu discover grounds of public policy of fraud or set aside an arbitral award on this basis. Then, my lord, please turn the page, or rather, my lord, the next para. The facts of the present case are nothing short of peculiar. Now, here, nothing peculiar. It is just a man who says, I don't know. And because I don't know, there's fraud.
More peculiar.
Divas has an arbitral award amounting to 562.5 million, along with interest and costs in its favor. While the arbitral award was published on so-and-so date, there has been 2 charge sheets. Here, nothing, no charge sheet filed by the CBI against Devas and other individuals alleging criminal conspiracy, fraud, and other corrupt practices on so-and-so date and so-and-so date, and the investigation regarding the same is ongoing. While proceedings in the underlying section 34 are pending, the Supreme Court has upheld the decision of the NCLT and NCLAT to wind up Divas on the ground that it was formed for a fraudulent and unlawful purpose, and the affairs of Divas have been conducted in a fraudulent manner. The Honorable Supreme Court in so-and-so has confirmed the finding of fact, which have attained finality and are binding on the parties and this court. On the basis of these findings, following observations can be arrived at. And your lordship will find, it says that these are the findings. And I placed it on the last day. I won't trouble your lordship.
Yes.
One para your lordship may not also look at, not a para starting with a reading of the aforesaid facts should be para 112.
Yes.
Clearly establishes that the fraudulent conduct of Devas begins from the very incorporation and extends to the agreement, Devas agreement, in its entirety, and all other actions pursued by it. The nature of fraud is so serious and complex that it not only resulted in the company being wound up under the Companies Act, but also led to criminal investigation against the company. In officers, Devas agreement itself has been obtained through a process of fabrication of documents and misrepresentation and constitutes a clear case of fraud. Such is the extent of fraud that it permeates through every agreement, transaction, or award entered into by Devas. The fraud is propagated by Devas is not only against respondent number one, but against the state as a whole, inasmuch as it attempts to obtain monetary benefits from the state itself by attempting to enforce an arbitral award, which is itself is arising out of fraud. And then it goes on to say that the findings of the Supreme Court should not have been ignored by the child court. So these were the peculiar facts, but your lordship has seen not how far this has gone. Now, my lord, this is based on the other judgment which my learned friends had cited, State of Maharashtra versus Hindustan Construction.
The specially petition was dismissed.
Against this.
Yes.
So after granting leave.
Yes.
Oh.
So we did not give it attached that probably. Well, the names appear in the first page.
Yes.
The order is 2 lines. Leave granted and then dismissed. I'm sorry, should have been with the
No, sorry. Yes.
with his leave. I'm just pointing out.
Your lordship has seen an award of $500 million against the government, didn't even call for discussion, So, like your lordship, like I have submitted, there seems to be an invisible policy. Now, this Delhi High Court, is based on, or rather, applies the principle of 2010 for SCC, which I also showed your lordship on the last date, State of Maharashtra versus Hindustan Construction. Now, here, what was being sought to be done was a amendment to the memo of appeal. Not an amendment in the ground, but an amendment to the memo of appeal. This objection, 120-day objection, taken. It's in this context. If your lordship would just take para 9 for the facts. State of Maharashtra, Hindustan Construction, 2010. তোরা দেখি
Hindustan Construction,
আমি দেখেন
No, this was not cited.
This was cited by Mr. Mitra. I distinguished it on the last day. I also distinguished it on the last day.
Yes. Yes, sorry, it's with me.
Hindustan Construction,
Yes, para 9.
No, para 14 should be adequate. But para 14 is the question. Mr. Ashok Desai, the learned senior counsel for the respondent, submitted that the Bombay High Court in Vastu has rightly held that new grounds cannot be permitted to be introduced into an arbitration petition for setting aside of an award beyond the period of 4 months stipulated in 34(3). He also relied on the decisions of this court in Milord Madanlal and Brijendra and 3 judgments, which are your lordship will find under footnote number 7, 8, and 9. So these were judgments under the old act. But one of them, the Bombay High Court, is under the new act. Bombay High Court referred to over there. This is the this is what was being argued here. In para 17, your lordship will find references made to order 6, rule 17. Then the learned judges consider these cases under the old act. That's para 20. Para 19, 20, those cases are not considered. I won't trouble your lordship. I'll assume for a second principles of the old act don't apply. I'll assume that for the sake of argument. And then, Millard, if your lordship comes to para 26.
Yes.
Where Madan Lal is considered, And my lord, if your lordship sees that my lord, under the old act, the position, my lord, if your lordship goes just below placitum E,
Hmm.
as in the present case, the objection was more than 30 days after notice, it could not be treated as an application for setting aside the award, for it would then be barred by limitation. The position thus is that in the present case, there is no application to set aside the award on grounds mentioned in 30 within the period of limitation. Therefore, the court could not set aside the award on those grounds. So, in other words, the ground must be there. A new ground can't be brought in post 30 days. This was the position under the old act. Lord, same thing in them, Lord, it was 30 days and not 120, because if your lordship remembers, there was a requirement for notice to go out from the court. The award did not become award, there had to be a rule of court. So, Lord, the 30 days started within Lord 14-1 notice. Then, Lord, para 27 is another Lord judgment. In popular construction, this court, kindly gives me 1 minute, Lord. Yes, this is 2001 8 SCC. In popular construction, this court, while considering the question whether provisions of Section 5 are applicable to an application challenging an award under Section 34, held, as far as the language of Section 34 is concerned, the crucial words are, but not thereafter used in the proviso to subsection 3. In our opinion, this phrase would amount to an express exclusion within the meaning of 29(2) of the Limitation Act and would therefore bar the application of Section 5. Parliament did not need to go further to hold that the court would entertain an application to set aside an award beyond the extended period under the proviso would render the phrase, but not thereafter, wholly odious. No principle of interpretation would not justify. Not your lordship is aware of this. Then, Lord, para 28, your lordship will find Lord, consolidated engineering again, Lord, 90 days plus 30 days can't be extended further. Now, Lord, the findings are, I'm sorry.
Limitation Act though. Because there is a fundamental, this something which is irking me, Mr.
My lord.
Bachawat. Here, Section 37 was being considered. So there's a distinction between a memo of appeal and an application. 34 is described as an application. It is intended to be an application, whereas Section 37 is appellate power.
Correct.
So a memorandum, the principle is, as we have learned it, that memorandum can be amended because, in the sense that
Absolutely.
it's not the litigant who is doing it, the advocates, because if you want to amend the memorandum, you don't require to file a supplementary affidavit. But if you want to amend an application, the body of the application, you have to take a supplement. The client has to affirm. So therefore, that also probably is regarding a memorandum, it's more liberal in a sense.
Absolutely, not absolutely, because not. Let me also not.
34 is an application.
Not, I'll put it. Not, I'll give you lordship one additional point there, which I had also not pointed on the last day. But in the case of a plaint,
Yes.
but there is really speaking no limitation for when amendment is to be allowed.
No.
Because not not allowing the amendment is not allowing not the truth of the contents. It is without prejudice and subject to proof.
Yes.
That is why the court says, look, even after 5 years, allow it without prejudice.
Yes, yes.
But not in a Section 34. Please not understand this. Not it is being heard and decided finally.
No,
If something is time
was,
barred.
amendment of plaint also, Mr. Bachar. If the relief could not be granted today, then amendment is also very strict on that. There are umpteen judgments, you know that.
It is not.
Time barred relief cannot be incorporated because it relates back to the date.
I can show you lordship Supreme Court judgments also, which says it is allowed without. Oh, a Calcutta judgment, not innumerable, not a Calcutta High Court judgment saying allow it without prejudice is subject to proof.
If
the fact that it is
question, yes.
The fact that it is barred as a matter of law.
If it can be a mixed question, yes, Mr. Bachar. But if the relief is time barred, if I want to introduce a relief, and that is time barred on the date of filing of the amendment application.
Or the usual thing in most of these matters, your lordship will find is that there is a pleading that I came to know within a period of.
Yes, right.
Bring it with you.
In fact,
right. That's a matter of pleading. Not beyond that principle of law.
If it's a matter of pleading mixed question, then it has to. It is generally allowed.
Not the Supreme Court has said, look, if it can be compensated by costs, impose heavy costs and allow it. That's what the approach has been now. Amendment, very liberal. Now, Lord, in this context, Lord, please come to para 29. There's no doubt that the application for setting aside an award under 34 has to be made within time prescribed under subsection 3, i.e. within 3 months plus a further period of 30 days on sufficient cause being shown and not thereafter. Whether incorporation of additional grounds by way of amendment in the application under section 34 tantamounts to filing a fresh application in all situations and circumstances. If that were to be treated so, it would follow that no amendment in the application for setting aside the award, however material or relevant it may be, for consideration by court can be added, nor existing grounds amended after the prescribed period of limitation has expired, although the application for setting aside the arbitral award has been made in this time. This is not and could not have been the intention of legislature while enacting section 34. Now, let's see how it mixes it up. Now, that same point which your Lordship has raised. More so, but one was looking here at amendment of the memorandum of appeal. More so, section 34(2)(b) enables the court to set aside the arbitral award if it finds that the subject matter of the dispute is not capable of settlement by arbitration under the law for the time being in force in India, or the arbitral award is in conflict with the public policy. The words in clause B, the court finds, do enable the court, where the application under 34 has been made within prescribed time, to grant leave to amend. Now, this is the principle over here. That is extended in Divas to mean that the court on its own can set it aside after finding grounds. But it's an expansion in what the Supreme Court really says. It enables the court, and the court finds, do enable the court where an application under 34 has been made within prescribed time to grant leave to amend such an application if the very peculiar circumstances of the case so warrant, and if so required in the interest of justice.
Now, Mr. Bachat, even if we accept that contention, let us take the difficulty to the next level.
Correct.
So
that's the fun part.
That's the fun part. Yes, absolutely funny. Because Mr. Bachat here, if you see because the proviso to 34(3) has been considered in the judgment.
Correct.
That's why it made me look into the language. If you please take section limitation act একটা copy ওনাকে দাও তো second judge's copy টা ওনাকে
I have it.
Oh, you have limit. Oh, আচ্ছা,
I'll just
your tab is there. Please come to section 5 once and juxtapose it. Kind of juxtapose, keep side by side with 34(3) proviso. What I mean to say, I'll be very specific. That's so that you can. Now, section 34(3) proviso says, provided that if the court is satisfied that the applicant was prevented by sufficient cause, this is on the premise that I accept your first proposition. Yes, it has to be an application, it has to be there. Provided that if the court is satisfied that the applicant was prevented by sufficient cause from making the application, blah, 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 can allow. So the court is satisfied, right? Section 5 says, may be admitted after the prescribed period if the appellant or the applicant satisfies the court. So it requires the applicant to satisfy the court. Section 5 requires an application, that's why. Because the appellant or the applicant has to satisfy the court that there is sufficient reason. But proviso is more liberal in the sense that even if they don't make an application or amendment or something like that.
Correct.
Court is satisfied, court may permit. But still, court has to be satisfied, definitely. Court has to record its satisfaction as far as my limited knowledge goes.
No, absolutely.
But satisfaction is required. But then onus is shifted to them in section 5. The appellant or the applicant has to satisfy. Here, court is satisfied, court can permit. So that puts it on a more liberal pedestal, probably.
Seems so.
Seems so apparent.
Seems so.
Even if an application is necessary, the ground has to be there. But proviso has been taken into consideration in Devas. That's why, I mean, we also have to think in that line. So even accepting the first limb of your argument, this is there. I have to be satisfied.
No, your Lordship is right, but satisfied on application. I'll tell your Lordship why. Please see the proviso to 3 again.
Yes.
Provided if the court is satisfied the applicant was prevented by sufficient cause from making the application within the set period of 3 months. But it's one common application. I am showing why there was delay in making the application, and that is going to appear from that
application is required for that delay condonation.
No, it's that
the application refers to section 34 application. Correct. The grounds.
So in that section 34, I am providing the grounds as to why I was prevented from making it earlier. So that is also by application, not probably to be read in. Has to be. He has to be satisfied from that application. It's a common application.
Why do you put that rider in? Then if that was the intention of the legislature, it would be in similar language as Section 5, that they have to satisfy. They don't have to satisfy. But court can be satisfied.
What, not the satisfaction is only to the extent of why he was prevented from making the application earlier.
Yes.
Within that,
Instead of making the application, you can read taking the ground earlier in this particular case.
I see. Give me a moment to not ponder on that.
Yes.
That changes it a little.
Yes. We can segregate by saying that, Mr. Bachwat, that let us substitute making the application by preferring the challenge. Preferring the challenge. Because this application speaks of this 34 mother application, parent application.
Well, let me ponder on this on a while. I don't want to not say something not
Very
Dixit. I'll not deal with
So
it.
then we read it like this, provided that if the court is satisfied in this particular case, ground taken later, provided that if the court is satisfied that the applicant was prevented by sufficient cause from taking the ground within the said period.
Let's read it like that for the time.
Yes.
Well, let's read it like that.
So we'll go into that,
here-
but that's
here-
the next stage.
Not here, really, that question of delay is only on that 30-day. But I'll assume that your lordship will be satisfied whether by application or otherwise. No, if his principal ground is accepted, he did not know anything. Your lordship will
that
have
is
to
always-
first come to that finding. He did not know it and he did not have the means to know it.
Yes.
Only then the question not arises of there not being any delay. If he did not know, there is no delay.
Yes.
But I'm not cutting the, let's put it this way, I'm not the junk out of the matter. Let's leave it. Let's not address this. Whether not in a matter like this, as a matter of fact, your lordship will allow a application without having the foundational facts.
Yes.
On the basis of, well, I guess, I surmise, I believe, I think, but I do not know. On that basis, whether or not your lordship will suo moto. This is not, I'm taking it to that bit. This is the argument. I have nothing, therefore, the argument not proceeds on the premise that there is nothing. Otherwise, why this invitation to do it suo moto? The invitation is to do it suo moto. Because the application itself doesn't have it. That is the premise. That's the reason they show these two judgments. That your lordship.
Mr. Bachchat, let us suppose for a time being, hypothetically, the records are before the court. A challenge has been preferred. The particulars of the fraud are not there, not pleaded at all.
Let's take it.
At all. The award is passed by Mr. X. Now, from the records is established. Suppose by admitted documents. I am taking the highest case for the court to show.
Let's take that.
Against you, the highest.
Yes.
Yes. So from the records, there's an admitted document to show that Mr. X was dead when the award was passed.
Right.
If the court finds there is no ground anywhere, but in the proceedings, I get the two documents. The award itself passed on such and such date, and this document he was dead. So then, can't the court suo moto do it?
So
without any pleading even.
First, let me take it at the lower level. Supreme Court window is in the peculiar facts of the case.
That peculiarity does not appeal to us. The number of millions is the peculiarity.
Correct. So whatever then your lordship will first at the very least.
And government probably, as you said, underlying. Yes. That's always there.
Firstly, that's peculiarity. But according to me, perhaps the Act doesn't contemplate. It is my understanding. I'll tell your lordship why. Because the language used further, which is not considered here, but I'll show your lordship from other judgments, that Milord must appear from the face of the award. So, Milord, if it appears from the face of the award that the man was dead,
yes,
it must appear from the face of the award. Then the Act enables it. The Act then enables it.
Yes.
But your lordship
the court is not absolutely powerless. That was
your lordship,
but not in the facts of this case. Here there are foundational facts. You are right, because they are saying that no award was passed, nothing happened, no arbitral proceeding practically happened.
Correct.
So if they have that case, then foundational facts, you have a point there. They may have to plead.
If I may just put it differently, appearing from the face of the award itself seems to be based on the premise that there cannot be an inquiry outside of the award. One cannot go looking here, there, a letter to so-and-so, a letter to the other person, producing it here before your lordship, because the object of arbitration, as I see it, is two parties choose a private court, if I may use that expression.
And we encourage that.
And
purpose is not to put a spanner in the wheels,
correct,
to facilitate.
Section 35, Section 5 makes it clear.
5 makes it very clear.
Now, Lord, given that situation, Lord, the courts have always been vexed with the question of, look, how much
far?
could I interfere? Because sometimes
True.
these are people who are not men of law. They can make those mistakes. The second is not something far more serious. There is endemic corruption in the country. So sometimes, Lord, some of these may be affected by fraud, which is why fraud is brought in to the act by not bringing in public policy.
We have to be very liberal. I've in a particular judgment, Mr. Bachot, I have held that fifth and seventh schedules, those cannot be read as strictly as, say, the Bangalore principles governing judicial conduct. Because otherwise, the purpose is to encourage arbitration. So you lose a pool of professionals if you are so strict. Because professional people always have professional dealings. If I choose an engineer, then I'll have to only choose retired engineers who did not have any business at all.
Right.
So they have to have some dealing, some truck somewhere with
Somewhere.
some connection. But
Because-
some connection cannot be taken in. Therefore, fifth and seventh schedules have to be strictly read in favor of arbitration, not to declare an award. I mean, not to declare someone ineligible. So similarly, here also in fraud, we have to be very strict in interfering. You are right on that. Strict interference is the norm. That is the principle embodied here.
But that's not a principle I need to, in fact, not argue. We
No.
were not only academically looking at this purpose, not the purpose of using these words of its own, not the court. But let me be a little bit more frank. The court can find. Does it not use the word? The court can by itself find. The court can suo moto find. We are adding words to the statute here. Now, the Supreme Court has said what it has, but in a very limited context, i.e., that of allowing an amendment. That's the clear language. That court finds do enable the court where the application under 34 has been made within prescribed time to do what? To grant leave to amend the application if very peculiar circumstances warrant, and if so required. This is what now
That probably, I mean,
to stretch it to say that look, court can suo moto inquire into facts where the established law is that the setting aside court does not go into facts.
finding happens, the may find happens at the stage of final adjudication. You have to put it on record by way of an application. You have a point there, Mr. Pachor. Not that court of itself, then no application is required.
Correct.
Court will go about hunting for awards and
Correct.
we
Correct.
find awards which
But-
look bad to us and we say.
But
That
look at
is-
the
that cannot be the
floodgates which will be open. Not all I need to do is
34.1 has to be read with 34.1. 34.1, you make an application and then at the adjudication stage, if the court finds, then it will set aside.
correct.
Right. Yes. Obviously, that is
No, but that is the way
this
it's
is
been
taking too
placed.
far.
But it
Taking
was
it a bit
said
too
that
far.
look, what if I have no grounds? The court can find. This is the argument made. I mean, I'm putting it not. I'm not putting it
If you
nicely.
say court may amend, then you are putting something into the statute, which is not there.
But that's what
with,
it has said.
with deepest respect.
So
Yes.
this is the not long and short of it. Not how far can one stretch this expression the court find? This is the question before your lordships. All that I'm saying is not. This is not a magic wand by which one can open up anything. Look at the floodgates argument. Now, I can file an application. My learned friend has filed an application challenging an award which is 5 years old. I'll challenge something which is 40 years old simply saying I did not know. I have nothing to show it. Let the court find it. Now, is the court then to not direct CBI inquiry and then find it? Or what?
CBI is
What-
already overburdened. So use some other. They'll file a bill someday.
So, but the language court by itself is not there. So, court will now delegate the power to someone else. Go find this fraud for him.
Yes.
But look at the floodgates argument here also, where there is a
Accepted.
complete principle of non-intervention.
So you have to strike a balance. somewhere.
That is all that there is. No, that's all that there is to it. I'm saying that this extreme proposition done by my learned friends does not satisfy not any principle of not statutory interpretation. Not statute also did not intend it, and that is what I'll show your lordship. That's the not interesting part. The word 2A had actually been put in by the Law Commission for some reason. It's not gone into that.
Oh.
I'll show that. So, this is where his argument started. So, I'm dealing with that now. If your lordship would take, diye dao na.
All discussed in silence.
हाँ, तो वही देख चुका.
Coordinate.
How much? join the line.
এটা কি নতুন judgment?
না না ওই স্যাংয়ং হ্যাঁ সাইড করিনি এখন
Sangyang.
yes but this is the one which considers it all but please give me one moment
Sangyang is like a Pandora's box. I mean, but everything,
not
it contains everything.
it does it does but just give me one moment
খুঁজে বার করা মুশকিল এত বড় judgment
Some days statutorily some restriction should be there. A judgment cannot be
more than
and the number of in double space, not more than 20 sentences in a.
some provisos and explanations also
Otherwise,
saying
we'll make it
that
micro
it
Xerox,
may be more than
microprint
100
and- Yes.
it may be more than 100 pages provided it only lists the cases like an encyclopedia
Yes.
and says this existing law ABCD
But then it will be done entirely by
yeah
AI or
Yes.
II, intern. Then the judges will do nothing.
My lord, this is something, my lord, which I had my own doubts and problems. But the Supreme Court says that shorten your argument. No, I won't allow you to argue for more than half an hour. Give the notes, written notes of submission. And thereafter, when the judgment comes out, it is 300 pages. Now, how does one shorten the submission when you are yourself delivering judgment consisting of 300
Absolutely. And some things are quoted in a civil revisional application against an order of this court. I mean, 1.5 page order against that 36 pages judgment. And Dworkin was quoted. Poor Dworkin did not even know about civil revision in Indian law. I mean, why blame
I heard
Dworkin? What did he have to do with section 115? Come
I
on.
heard some threatening news. I mean, whether it's true or not, there is a report circulating that I shouldn't read that some learned judges, just make submissions and suddenly the stenographers are writing only one portion of, and when the judgment is coming out, it's coming for several pages. Who has taken the dictation? Yesterday, SCC people came to me. They are launching AI now.
Manu has already
Yes, Manu has done AI SCC. I said launching, it will come for demonstration and all.
Very risky.
Free demonstration they are giving. I want they aside. I said, very well, I will take it. But have you already started? Which I know has started in Claude, CLAU, about drafting. That you feed in
all over the
and
newspapers.
the entire
Yes,
thing comes out.
Yes.
Have you started? We are starting.
আর ওকে বললে যে
They said we are starting.
একটা ধরুন
My lord, I only fear how threatening it will be if judges put it in the facts and the judgment comes out.
I can only tell you, Mr. Bose,
My lord,
you know very
I
little.
this.
You know very little. It's a constant problem. It's a constant problem. Constant vigil. Now some people are taking extreme measures. Like I don't have a law associate at all. My interns
No, that was happening
there.
for last 2 years. I heard. Like he said, how does Supreme
better not to have one. I mean, you have to take extreme measures to combat extreme things being done. I mean, it's a regular problem and not only limited to whatever. I mean, you can see from the judgments, Mr. Bose.
My lord,
If you read a judgment, Mr. Bose, if you read one of my judgments, I have ownership till the judgment is published. So if you see my judgments, maybe you will find that what
please
the
don't compare yourself.
no
with that.
I can only compare myself with myself. I don't have the liberty to compare
Sir,
anything.
we all know
No, sir.
what you are
But you'll find sometimes that the first part of the judgment does not tell you the language of the second part. There is something in the middle, no unity of thought, no coherence.
I know
So
with that.
there are telltale giveaways if you look into the judgment. Nowadays, these are so long, nobody
why he
reads to
said,
the entire judgment.
I have argued short note. How does the judgment? He wanted to say that. Well, I am
No,
saying.
he said sufficient. It's very difficult nowadays. Very difficult to retain your integrity even. I mean, what is happening if
only
if there's a tidal wave around you, it's very difficult to retain your integrity. As an advocate, as a judge, them also, or officers also.
That problem will be gone soon. I'll tell you, Lordship, why.
knows all everything. Something comes.
No, Mr. Bose, you're right. You have heard only.
You cannot do anything.
You have just learned about the tip of the iceberg. I'm telling you.
But that problem will go away with AI. I tell your Lordship, why. Your Lordship will be
Nobody will
required-
have a job anymore.
No,
We
your
won't have a
Lordship
job.
will
You won't have a job.
have to go through operation. AI chip will be put in over here.
And then we think
And
like that.
Your Lordship will only think and it will do everything.
Yes.
But where it has gone to, as Mr. Bose points out, I'm not joking about this. There are softwares available because all over the newspapers nowadays, one just needs to scan in the documents as a lawyer. Scan the documents in, you will read it, and you have to tell him, I need to draft a, let's say, criminal revision on the Bombay High Court, for the Bombay High Court.
Yes, yes.
So it will do that thing for the Bombay High Court, the format. Thereafter, one needs to check for errors, but that's it.
But I'm taking it one step further. You can also say it will be moved in this court. It will scan the judgments of that judge, infer bias, and write it that way.
Possible, yes.
Right?
Yes,
If you cannot read 100 judgments of a particular judge, it will read 1,000 judgments of that particular
in
judge.
3 seconds.
Identify a bias which the judge even doesn't know he or she has.
Correct.
And it will draft the petition in that manner, and it will make it ready for you.
But it's something I was aware of from
So
maybe
we are
10,
standing
15
there.
years ago. But I was surprised. As
So we have
lawyers,
met our biases also every time, every moment of the day.
as lawyers, we never thought of it. But I had a relative who was not in the legal sector. Their job is research, policy bodies. Now, for years, they have been researching to see whether there is a gender bias, there is a race bias in judgments of a particular high court. Then thereafter, they go into particular judges, etc. And these are published data, apparently.
Which are often skewed. I mean, what is called a gender bias? I mean,
no, I mean, I used a bad example. It may not be that. What I'm saying is,
not gender
they are
necessarily.
looking
I mean,
to
other biases also.
they're
Similar,
checking
same
to
logic.
do that. Now, Manupatra AI and Supreme Court AI, what will it do? It will enable you to actually now, it will enable a litigant or a lawyer to identify which way a judge's judgments go in a particular field, let's say.
Even the judge doesn't know.
Correct.
His particular bias.
Correct.
But this will know.
Dangerous.
Dangerous. Absolutely dangerous. Absolutely. So therefore, every moment you have to think whether you are biased this way or the other. I mean,
but that
you
itself
have to
is a
counter
bias.
your bias.
But that itself is a bias. Trying to correct the bias is a bias.
No, you cannot identify biases actually, because it's a contradiction in terms. If it is identifiable, it's not a bias. So therefore,
there has to be a bias. We are human beings. Otherwise, your lordships will not lose a sense of justice. The law may be against me, but the facts of the case required. Sometimes one will tilt that way. I'm assuming. I don't know how you.
I never take trials before the matter is moved before me, because I'll have a bias. If I go through the judgment, and that will be my judgment, not an adversarial proceeding.
Correct.
So I have to hear both of you and then decide. If I have a preconceived notion upon going through the file at home, then no use having this adversarial system at all. And if a judge can't pick what is the crux of the matter, say within 10-15 minutes, then he should resign. Anyway,
so not now going into
now let us come to instead of AI, A.
Yes.
To A. Yes.
Now this Sangyong it can be
Sangyong
is familiar with. Your lordship is
no,
familiar
which part of it now you are citing?
So now if I may just let me see how short I can keep the journey through Sangyong. So I'll just identify the issues instead of reading them. I think your lordship is familiar. So if your lordship would come to para 16, I don't know how much please give me a moment.
Yes, sir.
The paras are the same. Yes, they are the same.
Mr. Bachat, if you have a note somewhere, which paragraphs you'll be citing, I'll just take a note of that. We'll go
not
as we go along.
Not on this note. And I tell you, Lordship, most of these paras are not necessary. I'm just taking you, Lordship, through the journey. That's all. Nothing more, Lord. Delight. So, Lord, I'm not troubling your Lordship. Para 16 quotes Renu Sagar. So, this was pre-Lord 2015 amendment. Then, my Lord,
Para 16 does not quote anything.
Para 16 quotes para 18 of Renu Sagar.
No, this para 16.
Oh, I'm sorry, Milord. In mine it's. Oh. I'm sorry, Milord. Very sorry. It is in Renu Sagar. আমি এটাই দেখ করছি তাহলে।
Because I have the SCC.
No, your lordship
copy,
is right. Your lordship is right. Milord, I'm sorry. এটা কি? It is necessary to first survey the law.
Renu Sagar comes subsequently.
Not para 20 in yours.
Yes.
I'm sorry. Chart para. Okay. So para 16 quotes Renu Sagar.
Para
Para 20 quotes
I'm sorry. Para 20
Yes, para.
quotes Renu Sagar.
Yes.
And not on the next para, your lordship will find or at the end of that para. In mine, it's numbered. In this, it's not. To this statement of law, the court added that the binding effect of the judgment of a superior court being disregarded would be equally violative of the fundamental policy of Indian law. So, none of this is ultimately going to be relevant except for this. Please remember, we ultimately came down to Renu Sagar plus something.
Yes.
So, this was the original position. Then, your lordship will find, it refers to saw pipes.
22.
Not para 22.
Yes.
Then Western Gecko 22.
And in 22, your lordship will find para 31 quoted. Not this patent illegality was added by this. So I won't trouble your lordship with all of this. Then, my lord, your lordship will find at para 26, perhaps. Just give me a moment.
Western Gecko is
Para 24. Yet another expansion of the phrase public policy came in to Western Gecko and associate builders.
Yes.
And that is what was ultimately chopped down. So, what came in, if your lordship wants a summary, I'll just tell your lordship without taking your lordship through it. Judicial approach, this Wensbury principle kind of approach came in, audi alteram partem and application of mind and Wensbury reasonableness. That's what comes in there. That's what the next few paras are about. I won't trouble your lordship. Then, my lord, after that, if your lordship would come to must be Kuldeep Singh.
Para 26 is your law commission report.
Kuldeep. No, before that.
14 paragraph 34. No, paragraph 15.
It must clearly be understood correct, Paraj.
Paragraph 24.
24.
No,
Can't be.
Must be
But
clearly
please come
understood.
to where Kuldeep Singh is
Kuldeep Singh
quoted in
must be
para-
clearly understood. Para
Yes,
33 of Kuldeep. Yes, got
It
it.
must be clearly understood that when a court is applying public policy test to an arbitration award, it does not act as a court of appeal, and consequently, errors of fact can't be corrected. A possible view by the arbitrator on facts has necessarily to pass muster, as the arbitrator is the ultimate master of the quality and quantity of evidence to be relied on. Thus, an award based on little evidence or no evidence which does not measure up to the quality of a trained legal mind would not be held to be invalid on this score. Once it's found that the arbitrator's approach is not arbitrary or capricious, he's the last word on facts, my lord. It goes into all of that. And then, my lord, please come to the Law Commission para, which is not para 25.
6.
It is at this stage that certain fundamental changes were made in the law, para 25.
Yeah, 23. Yes.
Were made pursuant to the 246 report of the Law Commission, and, my lord, it tried to bring in the amendment. And the objective, your lordship will find in the note, not author's note, I suppose. This amendment is proposed in order to further demonstrate and reaffirm the Act's focus in achieving the objects of fairness, speed, and economy. Then, my lord, the Law Commission report, when it came to setting aside of domestic awards, prescribed certain changes. And, my lord, if your lordship goes to the para 35 of that report, it is for this reason that I'm sorry, my lord, I'll have to read the earlier para, otherwise it won't make sense.
Yes.
But once an arbitral award is made, an aggrieved party may apply for setting aside of the award. Such Section 34 deals with setting aside domestic awards and a domestic award resulting from an international commercial arbitration, where Section 48 deals with conditions for enforcement of foreign awards. As the Act is currently drafted, the grounds for setting aside under 34 and conditions for refusal of the award are pari materia. The Act as it is presently drafted, therefore, treats all three types of awards, purely domestic award not resulting from an international award, as the same. the Commission believes that this has caused some problems. So now, the problem is being identified. The legitimacy of judicial intervention in the case of a purely domestic award is far more than in cases where the court is examining the correctness of a foreign award or a domestic award in an international commercial arbitration. So, the mischief here is this. Courts tend to interfere more in domestic awards. This is what they are now trying to
But then go and see section 34 and 48, compare them.
But
Patent
they say it's
illegality
pari
apart.
materia. This is the language Law Commission is using. It's saying over here, language is pari materia. It is for this reason, now let para 30. It is for this reason that the Commission has recommended addition of 34(2)(a) to deal with purely domestic awards, which may also be set aside by the court if the court finds that such award is vitiated by patent illegality appearing on the face of the award. So, the stress is again on the face of the award. In order to provide a balance and to avoid excessive intervention, it is clarified in the proposed proviso to the proposed section 34(2)(a) that such an award shall not be set aside merely on the ground of an erroneous application of law or reappreciation of evidence. The Commission believes that this will go a long way to assuage the fears of the judiciary as well as other users of application law who expect, and given the circumstances prevalent in our country, legitimately so, greater redress against purely domestic awards. So, greater redress against purely domestic awards. This would also do away with the unintended consequences of saw pipes, which, although in the context of purely domestic award, had the unfortunate effect of being extended to apply equally to both awards arising out of international arbitration as well as foreign awards, given the statutory language of the Act. The amendment to Section 28(3) has similarly been proposed solely in order to remove the basis for the decision of the Supreme Court in ONGC saw pipes, and in order that in rendering the award becoming capable of, and in order that any contravention of the term of a contract by the tribunal should not ipso jure result in rendering the award becoming capable of being set aside. The Commission believes no similar amendment is necessary to 28(1) given the specific restriction on the public policy ground. Then, although the Supreme Court held in Mahel Progetto 2014 to SCC that the expensive construction according to the term public policy in saw pipes cannot apply to the use of the same term public policy of India in 48(2)(b. The recommendations of the Commission go even further and are intended to ensure that the legitimacy of court intervention to address patent illegalities, so this is the language in 34(2)(a), in purely domestic awards is directly recognized by addition of 34(2)(a) and not indirectly in accordance with the expansive definition of public policy. So it's a more restricted approach which is being brought in, and a direct one as opposed to going through a judgment. In this context, the Commission has further recommended restriction of the scope of public policy in both Section 34 and 48. This is to bring the definition in line with the definition propounded by the Supreme Court in Renusagar, Power, etc., where the Supreme Court, while construing the term public policy in Section 7, held that an award would be contrary to public policy if such enforcement would be contrary to the fundamental policy of Indian law, interest of India, or justice or morality. Formulation proposed by the Commission is even tighter and does not include reference to interest of India, which is vague and is capable of interpretational misuse, especially in the context of challenge to awards arising out of international commercial arbitrations under Section 34. Under the formulation of the Commission, an award can be set aside on public policy grounds only if it is opposed to the fundamental policy of Indian law or is in conflict with the most basic notions of morality and justice. So now, let's see this. Consequently, changes were suggested to the following acts, to Section 28, 34, and 48. And then, my lord, please see para 26 of that. Similarly, the amendment of Section 34 was prescribed as follows. Amendment to Section 34. In subsection Section 34, in subsection 1, after the words 2, add the word subsection 2A. So 2A was intended to go in 1.
Intended to go in 2.
Yes.
In 1, yes.
In 1.
1.
34(1) will include the word 2A. That's how it was intended. Not discovered this by chance, but not done.
No, this is very important actually.
Yes, it is. But because this is the argument I was making with them, that this should have been either part of 34(2) or it should have come in as 34(2)(c) or something like that.
Exactly. The Bachchat will just come back.
কতক্ষণ বলবো
আচ্ছা Yes.
Not to go back to that portion
Yes,
only.
yes.
Not para 26 of that Law Commission report. Similarly, amendment was prescribed as follows. So in the prescription, not 2A was, the words 2A were to go into 34.1. Then your Lordship could see the note below it. The proposed explanation 2 is required to bring the standard for setting aside an award in conformity with the Supreme Court decision of the Supreme Court in Renu Sagar and Sri Lal Mahal versus Progetto for awards in both domestic as well as international arbitrations. Ground C reflects an internationally recognized formulation. Such a formulation further tightens the Renu Sagar test and ensures that morality or justice terms used in Renu Sagar can't be used to widen the test. So, tightening down is what is intended. Then, 3, after the explanation in subsection 2, insert subsection 2A, an arbitral award arising out of arbitration other than international, not that
As it is, yes.
And then there's not the provisos there, then there's a note. The proposed section 34.2A provides an additional, although albeit carefully limited, now please not mark the word ground for setting aside an award arising out of such a domestic arbitration and not an international arbitration. The scope of review is based on the patent illegality standard set by the Supreme Court in ONGC versus SAW pipes. The proviso creates an exception for erroneous application of law and reappreciation of evidence which cannot be the basis for setting aside. So it's tightening the ONGC test. And Milord, it's making it clear that this is a ground like 34.2.
Yes, obviously, yes.
And then, Milord, section 48 we are not concerned with. Then, Milord, this is when the problem happened. After Western Gecko, Supra was delivered by this court, a supplementary report of February 2015 was made by the Law Commission. Para 10, Lord, is the 246th report of the Law Commission. So, Lord, Western Gecko messed up the entire recommendation. So, Lord, Para 10.1, the Law Commission in the 246th report provided for the same narrow standard, namely that a mere violation of law of India would not be in violation of public policy in case of international commercial arbitration held in India. It is suggested that substantial amendments to Section 34 with an endeavor to ensure that the Renu Sagar position applies to all foreign awards and all awards passed in international arbitrations. With respect to domestic arbitration, the Commission recommended that the patent illegality test be retained, although it be construed more narrowly than under SAW pipes regime. In this regard, the following provisions were added to Section 34.2b2 and a new provision 34.2a was introduced. These are stated as follows, Milord. I won't trouble your Lordship with this, Milord. Then, Milord, 10.2. 10.2 করে আছে তো। The above amendments were suggested on the amendment that other terms such as fundamental policy of Indian law or conflict with the most basic notions of morality or justice would not be widely construed. Then, Milord, came this fundamental change. However, a month after submission of the 246th report, in August 2014, the term fundamental policy of India was construed widely by a 3-judge bench in ONGC versus Western Gecko to include an award that no reasonable person would have arrived at. So, Milord, this messed up this situation and the supplementary report there. This permitted review of an arbitral award on merits on the basis of it violating public policy. Supreme Court decision was followed by a subsequent 2-judge bench in Associate Builders. In the words of the Supreme Court, and then, Milord, that is set out. I won't trouble your Lordship. Please come to Para 10.4 thereafter of the Law Commission report, supplementary report. Such a power Such a power to review an award on merits is contrary to the object of the Act and the international practice as stated in the Statement of Objects and Reasons of the 96 Act itself. One of the principal objects of the law was minimization of judicial intervention. And that's then the objects and reasons. Then got 10.5. As the Supreme Court judgment in Western Gecko would expand this court's power further.
That's the explanation 2 came in.
That's right. So, my lord, to get rid of basically Wednesbury reasonableness, my lord,
Yes, yes.
10.6, this will have not, it says what will be the effect of this not Western Gecko. 10.6 minute says this.
Yes.
This will have four major deleterious effects, being further erosion of faith in arbitral proceedings amongst individuals and business in India, a reduction in popularity of India as a destination for international and domestic commercial arbitration, increased investor concerns amongst domestic and foreign investors about the efficacy and speed of dispute resolution, and potential for judicial
Then the
interference.
Galgotia judgment came recently.
That's Galgotia. But I can't say I'm familiar with that. But I can't say I'm familiar.
There's a university called Galgotia, which
Yes, yes.
So that made people pass a judgment on Indian commercial environment.
But there was something in the newspaper recently about Galgotia is holding some major conference, law conference with a lot of people. I saw a 2-page advertisement or something. No?
Yes, China. That dog.
Dog
road.
Robot
was
dog. Yes.
I
In
mean,
the AI.
saying
Was roaming about.
Yes.
about.
Then when
And I was
Made from a
it started sniffing, then it was caught.
It was
The
made
Indian
from a
dog.
Chinese kid. And they were expelled.
Yes. Yes, they were expelled.
They were expelled.
then say sorry. First they denied everything, and then they said
No, the lady, the professor who had given that interview, which started this entire raked up the issue, she later on gave another interview to explain, and she said something like, I said something which is unsmart, which never happens, Shaggy, which is not the norm or something, which never happens. Just- yes,
And blood.
yes. So
And D, an incidental increase in judicial backlog. So, my lord, it's all of this is considered. In this regard, the following amendment to the draft is suggested by inserting explanation 2A. And then, my lord, pursuant to the Law Commission report, the 1996 Act was amended by the Amendment Act of 2015 with effect from 23rd October. 15 statement and objects are set out. Not, I won't trouble your lordship. Not all of this is known to your lordships. And then, my lord, your lordship comes to para 35. By the way, what is clear? What is clear? Correct para ache. But para 34 of your lordship's judgment. What is clear, therefore, is that the expression public policy, no, we're not really concerned with it here, whether contained in section 34 or 48 would now mean fundamental policy of Indian law as explained in para 18 and 27 of the associate builders, i.e. fundamental policy of Indian law would be relegated to Renu Sagar understanding of the expression. So, the law goes back to not. This would necessarily mean that the Western Gecko expansion has been done away with. In short, Western Gecko, as explained in para 28 and 29 of associate builders, would no longer obtain, and all of that is not cut down. I won't trouble your lordship. Not this is all academic. Then, if your lordship sees para 38 and so forth, but para 37 of your lordship's.
that's yes.
Insofar as domestic awards made in India are concerned, an additional ground is now available under subsection 2A added by the Amendment Act to section 34. Here, there must be a patent illegality appearing on the face of the award, which refers to such illegality as goes to the root of the matter, but which does not amount to mere erroneous application of law. In short, what is not subsumed within fundamental policy of Indian law, namely contravention of statute not linked to public policy or public interest, cannot be brought in by the back door when it comes to setting aside an award on the ground of patent illegality. And then, my lord, if your lordship sees a heading at just after para 42, section 34, 2 small a does not entail a challenge to an arbitral award on merits. So, my lord, now I'm just showing your lordship only the broad topics. It's not relevant for us. It considers that, and then, my lord, if your lordship will come to, but it goes across the law in the whole world, not after this.
Yes.
Not it considers a ground of challenge under each of these, not 2A1, 2A1, 2, 3, etc. Looks at the law across the world. Not.
Yes.
And Lord,
And the foreign judge.
It's no point troubling your lordship with the law across jurisdictions. Not that is really what it is, but not from here. Three things emerge, not which support the argument which I made on 34.2. Not this 34.2 capital A has to be read as part of not section. It is as if it is a part of 34.2 itself. The fact that a capital A is made does not make it an independent not subsection which is not covered by 34.1. Not use of the terms 34.1 and 2, 34.2 and 3 in 34.1 includes 2A. And that was the intention which is borne out by that Law Commission report, which specifically not said that that has to go in there. Now, it's obviously not gone in because those words were superfluous, because 2 will include 2A. Or it's some mistake, I can't try and explain that. But the fact that the Law Commission said that it ought to go in, and it's not gone in, of course, can mean two different things. It means that
it has to go. Otherwise, there cannot be any challenge on that ground.
correct.
Because 34 says recourse to a court against an arbitral award may be made only by an application.
Correct.
So court
Correct.
cannot of its own look
Correct.
into it if there is no application.
Correct. So,
No doubt about that.
correct. So,
2A has to come in
so
within
therefore,
one.
it must be read as part of 34.2.
Otherwise, 2A could not be used at all.
That's what I was saying.
Yes.
It is just an additional ground of challenge. But
Yes.
seeking to restrict what the law actually meant. It's a restrictive provision, a restrictive ground which is there. But it is meant more perhaps not to explain what the law is by excluding certain things rather than including. That was the object of it, which your lordship has got from the Law Commission report. Now, the fact that this is not meant to be a magic wand to open up just anything and everything on blood by use of the word court finds, it can't meet court finds by itself. Not please take it to be my argument. Not that court finds, not the words by itself is not there. Suo moto is not there. We are reading not words in. I can't help it that the Supreme Court has said so. But it's there. But it can't mean that. Particularly given the context of what the Law Commission has said and otherwise, but it can't mean that. One would have to read not words in by itself. And that is something which is fundamentally opposed to the Indian policy of the judiciary. The court does not itself find anything. It's an adversarial system.
Mr. Bachauti, is 2A relevant at all in the present challenge?
They have brought it.
Patent illegality, why do you say? I mean, because it has to be come under 2B, this fraud.
Look at the, if there is an award, look at the award, patent illegality, because subsequently documents show they have admitted the dues.
Oh, on that.
Yes, patent illegality is the ground.
All right. Yes. Right.
So that those documents
I was
are not
focusing on that.
But those documents are not part of the award. It must appear from the face of the award. So that's how. But my learned friend made the argument. That's why I'm meeting. Not it's in the context of his judgments. He took it further to say, look, it doesn't matter. The court can find by itself from anywhere. It's not necessary to be there in the application. Your lordship can find it. This is the argument made. So I'm just meeting that. Now, to wind up this chapter, just one judgment, also not one further argument, it would be reading words into the statute. I've already said so. One further argument, let us leave aside judicial intervention, interpretation, or the interpretation given by courts for one moment, and let's look at it. The same word is used in 34, section 34, 2B, court finds. Now, let's just see over there. If 34.2 is to be read by an application, court finds on an application, then the earlier interpretation that which is sought to be given, that 34.2 capital A is not an application but the court by itself. That can't stand. I'll tell you lordship why. Because the word court finds in 34.2A and B at 2 capital A must be given the same meaning. It's used in the same section. So I have a judgment for that. If in the same section one word is used and it has a particular meaning, the same meaning must be given to it.
Well
So,
said. Yes.
it's a well-established proposition.
Exactly, but you can cite it to round off your arguments.
Para 17 ছিল না?
এটা না
আছে আমার মার্ক করা আছে। ও বাবা, কোথায় হারিয়ে গেল এবার? দাঁড়ান। না, don't worry, I'll have to find it.
You're telling yourself or Mr. Khush?
No, I'm telling him. But
Don't worry.
somehow I managed to lose everything here, so he was handing me a judgment. But I managed to close that folder. Please give me one moment
Please, yes.
to reopen it.
কি proposition? Proposition
এটা কোনটা?
section এ যদি একটা word
Yes,
থাকে,
but please come to para 17.
এই body থাকে, তা একইভাবেই। Will not.
But halfway down, I won't trouble your lordship, but halfway down para 17, ordinarily the rule of construction is that the same expression where it appears more than once in the same statute, more so in the same provision, must receive the same meaning, unless the context otherwise suggests.
Yes.
So, Lord, this is for that. And Lord, one last judgment, Lord, I cite.
তুমি এটা para 17
Para 17, halfway down.
This is in line with ejusdem generis and all those principles.
Yes, yes.
The nocitor and
will accept it proposition.
দিয়ে দিয়েছি তো না? না তো আপনাকে 2022টা দিলাম কি?
না,
একবার
তুমি আমাকে দিয়েছিলে 1990।
Sorry. But here also the court considers the law commission and all of that. And what it's saying is not that these new grounds which have come in via the amendment are not a magic wand to open up anything and everything. That's not the language used, that's my language. If your lordship would come to para 22 first.
yes.
The 1996 Act was enacted to consolidate and amend laws relating to.
No, that is not correct.
মিলছে না কেন? ও আমায় অন্য দিয়েছে। এটা কি করে হলো? এটা কি করে হলো? Now, please give me a moment. But, I don't know, we end up with different copies. Please give me a moment. Oh. No. Help me. এটা ম্যাচ করবে? But please come to para 23. The limited grounds provided under section 34 of the Act has been interpreted by this court on numerous occasions. In this case at hand, the challenge of award is based on the fact that the same is against public policy and patent illegality. Public policy is as a ground of challenge is always met with certain skepticism. The phrase public policy does not indicate a catch-all provision to challenge awards before an appellate forum on infinite grounds. However, the ambit of the same is so diversely interpreted that in some cases the purpose of limiting the section 34 jurisdiction is lost. This court's jurisprudence also shows that 34(2)(b) has undergone a lot of churning and continues to evolve, and that will happen as long as there are intelligent lawyers,
and unintelligent judges,
astute lawyer
who are convinced easily.
It will evolve because judges also find the way. Judges also.
The combination has to be intelligent lawyer and unintelligent judge, or the opposite. Otherwise, it won't work.
It's both. I tell you, lordship.
Both are intelligent or both are unintelligent, then doesn't work.
No, Lord, if both not do their work, I tell you, lordship, law evolves and in the right direction. Then it evolves in the right direction. Perhaps not. I may be wrong in these
in
things.
A particular direction, right or wrong, positive.
Well, that's also
true. One thing is not being added by my learned friend. The law will evolve with cunning litigants. If the litigants, my lord, are comes out
ingenious,
yes.
That's true.
Then, my lord, the law will have to evolve.
Litigants ultimately mostly
they, my lord, it is they, my lord, who make the law.
Instigate the law.
Yes, the law always follows the society, social norms, always.
Yes.
And my lord, when it is found that the society is full of litigants who are cunning, who are clever ingenious, my lord, the law will change.
True, right.
That is how it does.
My learned friend, is right. Necessity is the mother of
Mother
invention. When one is faced with a challenge, then one is looking at pushing the boundaries of law.
Absolutely.
And it requires
It
not
changes in
just-
that direction.
but
Right.
it requires not just intelligent judges, but bold judges to push it where it's required, perhaps.
Has to.
This court's jurisprudence also shows that 34(2)(b) has undergone a lot of churning and continues to evolve. The purpose of Section 34 is to strike a balance between the court's appellate powers and the integrity of the arbitral process. Then Lord Renu Sagar
All
is
the
quoted. I won't trouble your lordship with that. And Lord, your lordship will find that Lord, it construes it narrowly. Then ONGC is not quoted.
Hmm.
I won't trouble your lordship with all that.
Para 38.
Lord, goes into the other judgment, but these are the lines which I liked, Lord. But this is the practical line for which I have actually showed it to your lordship. The law will continue to churn. Lord, your lordships have to strike a balance.
Yes.
But your lordships will have to strike a balance
Cycle.
in, Lord, exercising jurisdiction under Section 34, bearing in mind the magic mantra, please stay away to the extent possible, and except for grounds specifically mentioned in 34, and now courts have not kind of defined even not the terms in 34. To the extent not 34 itself is not providing it with the aid of explanations and provisos, even there now the courts have narrowed it down a lot. So this concludes my submissions on Section 34. This new spin on court finds. To which I'll add one more thing. Court finds must also obviously read into it. Court finds in accordance with the laws, laws of limitation, procedure, pleading, etc. It must be in accordance with law. Court can't just get into a fact-finding mission on its own and ignore the law in coming to the finding. So, this is my submission on. But if I may just, if your lordship may permit me to take another 5 minutes just to wind up or
Please.
tie up the loose end.
On a different day.
No, right away.
Yes, absolutely.
Right away.
Why are you
But
taking permission for?
No, because I've already made my submissions. So I'm just
Yes.
not trying to tie up the
Do,
loose
please
ends
do,
or whatever it be.
Yes.
Not, Oh, there are two matters. Yes, there's a little
matters.
distinction between the
Distinction, yes.
two matters. I'll just go into that in a moment. But I might as well just wind up my submissions on
Yes.
this. Court finds. So, to take off from this 34, court finds, I say, it must be based on grounds and the material given to your lordship. It cannot be court finds on its own or jumps to a conclusion based on nothing given by the applicant, but simply saying, look, I have a suspicion of fraud. I don't have the material. I don't have anything to say so. I'm not asserting myself. You please go and find it. No, that is not permissible at all under the current framework of the Indian law as it stands. To accept this argument would open up the floodgates to everything, which is not the intention. It's not the intention. We are in an adversarial system. You produce the data, you produce the facts, you produce it, you assert it, you do so legally with grounds and pleadings. The court will then not look into it. But on the basis of, I think, this may be the situation, it may not be, I do not know, I don't have the documents, but maybe I do. This is not permitted in any, this would not even pass the threshold in a suit. Let me put it this way. Let alone is Section 34 where the standards are much higher. Now, but if I may just tie it to the facts, case he came with is there was no Section 21 notice. There was no, there was no Section 9 application. There were no such proceedings. There was nothing. There was no Section 21 notice, no arbitral proceeding, and no what. This is the case he came with. But apart from this being suppression, which has not other consequences, which I'll deal with last, not apart from having suppressed it, when we point it out, and he came with the pleading that these are the only documents which are there. The records do not show anything more. When we point it out, then, my lord, he comes up with this supplementary affidavit and a and not the only thing he has is one self-serving letter written to an advocate. That letter is not on record, but the reply is. That is all that there is. On this basis, my lord, he comes to court saying there is nothing. When something is shown, he has no reply. I've showed your lordship the pleading where he says, I do not know why the Section 9 was withdrawn. He says so. There is no explanation. He does not explain all the other things which we show. That in the course of that there was a Section 9. In the 9, we offered to return. There was a prayer for not seeking return in that Section 9. But that letter is put on record. Then the application is withdrawn. So not a Section 21 notice would have followed naturally if not there was no return. The award itself shows that in the course of arbitral proceedings, not evaluation is done and the asset is handed over.
And they deny having received back the machine.
They do not deny. They do not.
They say somewhere that I deny that paragraph.
There is no positive statement. Not there is no positive statement that I have checked my inventory list and there is no such asset.
That there is.
There is also a bare denial. I showed your lordship.
Bare denial, yes.
A bare denial not is as good as nothing.
I deny that the page 10.
Yes.
I deny that the petitioner received the stacker from the respondent.
Correct.
On such and such or as alleged or at all. So that may go against them in a sense because I'm putting Mr. Mitra and Mr. Bose also on notice that because if they had received back the stacker, then there would be no reason for going for a further arbitral proceeding. That might have been their argument also. I've received back the machine, so why go into arbitration again?
Correct. Now, it's been received during pendency of the proceeding.
No, or otherwise, the statement is very clear. I deny that the petitioner received the stacker from the respondent on March 9, 2020 as alleged or at all. So at no
It's
point.
a bare denial is all I'm saying. But what I'm saying is,
yes.
No, this being said here is no use. I tell you, Lordship, why. The award itself records that the machine has been handed over. Should it not be a ground in his Section 34 itself? I do not have the machine. No machine was given. No valuation was done. But this should have come there. It should not be coming over here. So, all of these facts, where does it lead to? The case run is demolished with records to show that what he says is not only inherently unlikely, but at least 3/4 of it is incorrect. Because factually, there is a Section 21 notice shown. Now, what does he say in return? Well, the arbitral award has some mistake on the date. There's a 1-day difference in date. You took 6 months to reply to the Section 21 notice. Now, can the court get into this fact-finding on the basis of the award? Can't be done. Can't be done. But particularly when the factual assertion which was there, and those are not assertions, please remember again, submissions are found to be incorrect and there's no one to take responsibility for anything, let alone fraud. But this fraud at least can't be entertained on this basis. Particularly when he shows no interest in finding out for himself, doesn't ascertain from the erstwhile management or the administrator or anything. Now, then I've already pointed out nothing mentioned as true to knowledge, except paragraphs 2, 3, 6, and 7. Fraud, verification, no proper verification, no pleading, no proof. Court can't look into it. This kind of conjecture and surmise won't do. Lord, suppression, I've already made my submission on. Just one other thing, Lord, I just want to take your Lordship to one section in the Arbitration Act. Lord, please take section 39 once, Lord. But I don't know whether it goes in my favor or it goes against him, but I think it's important to point it out.
Refusal of the arbitrator to give the award.
Yes.
I mean, give a
Now, my Lord, he had a remedy for that. He had a remedy.
section 30.
He doesn't want to take that chance. Now, please see not section 39. Subject to the provisions of the subsection 2 and to any provision to the contrary in the arbitration agreement, the arbitral award shall have a lien on the arbitral award for any unpaid costs of the arbitration. Now, my learned friends have placed on record their post facto letter to the arbitrator. Arbitrator has said, look, you pay me my fees. Now, my lord, what if the arbitrator does not give it? In law, there is a lien. Now, subsection 2. If in any case an arbitral tribunal refuses to deliver the award, except on payment of costs demanded by it, the court may, on an application in this behalf, order the arbitral tribunal shall deliver the award to the applicant on payment into court by the applicant of the cost demanded, and shall thereafter, after inquiry, etc., order that the money be given or not. Now, Lord, more than a year has lapsed, year and a half has lapsed since Lord, even that correspondence. Could have easily said, look, Lord, if he was so sure, 2 years have elapsed, he should have made an application saying, please deliver it. But he would have then had to deposit costs into court. So he is avoiding that also. Because he is not sure what the outcome will be. What is there behind the wall, he alone knows. But if there is a fact finding, what will emerge, no one knows. So that's the reason, my lord, not only no true to knowledge, nothing, not at all, but even a power of attorney, not everything is behind a not opaque wall. We don't know who is saying all these things. But I think the only thing I can not end up with is this. But this whole entire case which is run on the basis of a simple mantra, if I may put it this way. I am the new management. I don't have anything. Now, forget corporate jurisprudence which says, look, it doesn't matter new management. Forget that. Look at the effect of this. In every case, anyone would be free to say, I do not know. Look at the floodgates it would open. I do not know. Old management knows. So who stopped him from asking the new management? But I mean, the question over here is not whether the new management knows. The question is whether the company knew. And there is not a iota of evidence to show that the company did not know. Nothing. And no attempt by him to do so, although he claims to be the company. He does not say that all the old employees are gone. Doesn't say so. He casts aspersions on letters issued by the employees, which we have disclosed now. He says they were undergoing notice period. So what? He says he didn't belong to the legal department. But you can't throw aspersions on everything. Everything can't be based on that. Forget not aspersions which have been cast on the learned arbitrator. But perhaps not morally right. One can't do that. You say very clearly, look, this is fraud. And I say so, and I have this to prove it. You cannot say, I guess that this must be fraud. But my learned friends must, I don't know, face some consequences for such reckless statements. And that is not that is a key artist. But I have already made the submission. I've showed your lordship all the documents. My learned friend wants me to show your lordship that even in the legal notice sent out by Mr. Aditya Kanodia, he nowhere denied the award. He did not deny the award even till filing of the till the day before, couple of days before filing of the application. So, this is just an afterthought, because otherwise limitation would have stared them in the face. So he says, as the new management, I came to know from your affidavit filed against the company on a particular date. So this is just an attempt to get out of limitation.
And the post-award correspondence, which they say is an admission on our part that there was no award, is basically referring to a reconciliation.
But my learned, but please don't mind it. But please don't. But he has worked extremely hard on it. Please give him not a few minutes. Please.
Well, only one thing, Lord, with regards to the admission that they are saying that we have not responded to the award having been passed in the common communication, we have not refuted it. My Lord, it refers to, my Lord, a reconciliation statement. If your Lordship, I'll just show that now. My Lord, they have written a letter to which we have given a response. In the response, my Lord, we have not denied that there is an award, that this is not my due because there's an award. That is their contention. In the reply, what we have said is this, that because there are several accounts, we have only stated that there was a reconciliation and that reconciliation statement is there.
Yes.
That reconciliation statement is prior to the award.
So what is the necessity for this?
Exactly, my Lord, because it is their contention that I have admitted that there is no award because I have not referred to it in the reply.
No, if
That was,
no. My question is against you.
yes, my
If
Lord.
the reconciliation happened before the award, then what was
Yes.
the necessity of this proceeding?
If the reconciliation, because it was not dealing with one particular contract and with several contracts, that reconciliation statement would only show that what was pending as on 8th of
Award does not speak
20th
anything
of-
about. Award does not say anything about prior
No, I'm
reconciliation.
only saying that the reply deals with the reconciliation statement. That is all. That wouldn't negate the fact that there's an award.
This is page. Give a, put
Yes,
the
sir.
page number in your written notes. Sir.
I'll do that, my Lord.
When you
We'll do that.
yes.
Great.
If you don't mind.
হ্যাঁ নিশ্চয়ই, of course, আমি কোথাও যাচ্ছি দেখ
Could I just have your lordship speak for 5 minutes?
Yes, yes, absolutely. So you're done. Huh?
Yes, yes.
Well, I shall start today because well, I do not want to give them an opportunity of coming back next day and saying that I've got some further things to add. Well,
No, you can complete today because I'm taking up original set matters today up to 3,
today-
unless you have some difficulty. Because there are too few average set matters. So
no,
that's
up to 3 o'clock, I will.
fantastic.
Yes.
Yes. Then we'll hear you.
Very well. Very well. Lordship, my lord, may I start this way?
And Mr. Bose also has to be there.
Yes, Mr. Bose, if he is
Lord,
not there, then well, I don't get the inspiration.
Please don't impose that restriction on me.
No, no.
After 2 o'clock.
You have done your duty sufficiently.
My lord,
Yes.
one or two things, my lord, I want to make it clear. This, my lord, we filed the application for setting aside or for whatever it is on the 19th of April 2024. My lord, according to what has been produced before your lordship, after the award is dated, your lordship has been pleased to see, the one award is of 17th September, the other is 21st September, both of 2020. Now, on your lordship sees that we came to know of it. This is our case on 25th January 2024 from my lord the proceedings before the NCLT, and this I have shown my lord at page 260 of the volume in the first matter. That's 529. Now from there we are saying 25th January 2024. This was annexed to their affidavit, which was filed in reply to my lord the application before the NCLT. And my lord, there is no dispute. We came to know of it from that day. That is our case. Now, in January, we have got 6 days. 25th January 2024, we received it.
Yes.
In February, that was a leap year. So 29 days.
All right.
Then March, 31 days. And April, 9 days. All told, 85 days. So on the 85th day, we filed it on the 19th April 2024. So
From knowledge, you were within 10.
yes, I'm within time. Then I'm not stopping there. the supplementary affidavit in which, my lord, the further documents were annexed, my lord, that was filed on the 17th May 2024. So I calculated that it comes to 113 days, which is within 120 days. So, my lord, so far as and my lord, this supplementary affidavit was filed after the leave was granted in the presence of my learned friend's client. Therefore, that being the position, in so far as the limitation question is concerned, that will not be available. Now, my lord, in order to meet that, they have purported to, my lord, disclose a document, my lord, in reply that, my lord, the copy of the award was sent to us, which my lord, we have not received. We said that this is not in our records. This is something manufactured by them again. And I shall give your lordship the date.
Ground below original application পড়ে দাও
Yeah.
এখানে একবার সবকটা পড়ে দাও every point was taken
না ঠিক আছে পরে আসছি দাঁড়ানো না আগে একটা পয়েন্টে
That is the next limit over. You're going too fast. You cannot do your matter at 2, the other matter. We will ensure that. Mr. Mitra and I, we means among ourselves.
So, my lord, so therefore, my lord, insofar as the limitation is concerned, on the basis of this, we have come before your lordship.
Right.
Second point on this issue is this, that I have shown to your lordship section 35. Section 31, subsection 5. And I have submitted to your lordship that section 31, subsection 5, it says, after the arbitral award is made, a signed copy shall be delivered to each party. And my submission has been this, on the basis of, my lord, authority which I cited, that this has to be done by the arbitrator. Once, my lord, the arbitrator has delivered, and delivery, my lord, there are decisions on this. So delivery means whom, insofar as government department is
yes.
concerned, etc.
Personal.
I'm not going into that. So, my lord, what is my contention is this, that until the arbitral award is, with a signed copy of that has been delivered, my limitation does not start running at all. So, my lord, I have given your lordship the calculation, but I submit to your lordship in addition that this is not necessary. I don't have to satisfy your lordship on the basis of the calculation of the days, which I have done. Because what I received was a copy which was annexed by them in their affidavit in reply in an NCLT proceeding. From there only I came to know of it. So, my lord, limitation question does not arise, firstly. Secondly, what is our case? Our case is this arbitration award did not exist at all. It was not there. But what is happening is this, on the basis of this document, my entire claim is sought to be nullified. So unless I get an order from your lordship, unless, my lord, I get, my lord, a judgment from your lordship on this issue, well, I am not able to, my lord, proceed further for the purpose of my enforcement of my claim. This is the most important thing. There is no award, I say. But what is being shown, wherever I go now, my lord, this award will be shown that, look, there is no claim insofar as this contract is concerned. Therefore, you cannot proceed. Therefore, I will have to have some kind of a declaration, some kind of an order, some kind of a judgment from your lordship for the purpose of, my lord, nullifying this document. And my endeavor before your lordship is to nullify this document. So all these arguments, my lord, which have been made by my learned friend is on the basis as if there exists an award. And I am challenging that. I am saying there is no award. And you have not been able to produce anything to show that there is one. Second thing, and most important thing is this. This matter is being heard before your lordship for so many days. Before that, my lord, application was made. There are various proceedings. Well, I expected that so far as the claimant is concerned, who is holding an award, to produce the original copy of the award, my lord, which has been served upon him. It is not there. I expected the statement of claim filed by them, copy of that. to come before your lordship. It is not there. I expected their counter statement of facts disputing this claim. That is not there. I expected, my lord, the minutes of the meeting, copies of which, my lord, must be lying with them. Where are they? Not one. Surprising. I can understand, my lord, the minutes, the original minutes are lying with the arbitrator. But what about you? You have the records of the proceedings, evidence, argument, decision cited, report of the my lord, of this surveyor. You do not produce anything. On what basis will my learned friend's client be able to invite your lordship to hold that there is an award? No, bhai. They are saying that there is an award. I expected, my lord, they should produce before your lordship the signed copy of the awards which they received. In fact, they did not receive. I tell you, lordship, why? Kindly, my lord, take the petition. Lordship will be pleased to see. Well, the entire issue, my lord, turns on the facts of this case. Your lordship will be pleased to see that letter of the arbitrator at page 347. देखिए, this is a very, very significant letter. Dated 5th March 2024, after we wrote to them, after we came to know of it from the affidavit and reply in the NCLT proceeding. We immediately wrote to the arbitrator saying that give me a copy of the award. And this is, my lord, what the learned arbitrator says. Claim amount in this letter, she says in the last paragraph before that that chart, in the said matter, I have passed award dated 17 September 2020 and 21st September 2020, in which it may be noted that following charges and details below are pending from your client. Kindly note your client, Mrs. Shrey Equipment Finance Limited. Award, first award, claim amount 1 crore 89 lakhs. Arbitrator's fee 6 lakhs 41,000. Fee for study the pleading 70,000. Venue secretarial assistance 65,000. Total 77,000. My lord, this comes to at the arbitrator's fee on the basis of fourth schedule. It comes to 5 lakhs 34,000. Your lordship sees arbitrator's fee 6 lakhs 41,000. Fourth schedule calculation, it comes to 5 lakh 34,000. So, my lord, if the party, if my learned friend's client has paid the fee and obtained a delivery of the award, then, my lord, half of this amount should have been paid by him. The arbitrator says this total amount due. That means, my lord, nobody has paid her anything. And, my lord, nothing is being claimed from them. Your client, if you want to get a copy of the award, pay this amount of money. Otherwise, I will not give you. How did they get it? Did they get it? I am just asking this question. Did they get a signed copy of the award signed by, my lord, Mrs. Vandana Ray, the district judge? They should have produced that. I was waiting, my lord, expectantly that they will produce, my lord, in course of the hearing, at least, my lord, the signed copy of the award which was given to them, that here is the award I have received. Why have you not received? Because you have not paid the fees. They did not say that. I expected, my lord, that I was just waiting. In fact, my lord, when I received the brief, I said that your case cannot be correct because they must be having all the documents, everything, copies of which will be produced. And, my lord, they did not produce things, a scrap of documents. And if whatever has come, my lord, it has come from us. Whatever letter, my lord, we could discover and all. But I submit that all these issues with regard to verification.
So that report came from them, the surveyor's report. Say they have produced that document.
Well, what has they have produced, my lord? I have made my submission. I shall say indicate to your lordship what they have produced with regard to surveyor's report. This is not, my lord, what it is. And my lord, 75 lakhs is supposed to be surveyor has, and my lord, your lordship has been seen the condition of this. I shall come to that. But what I am on is today, we had thrown an open challenge to them that you produce any document to show that the proceedings were had. I say that if you cannot produce arbitrators' records, produce your own records. Produce your own record. I'm surprised, my lord. What we do at the time of my lord hearing of a setting a set application, we produce the documents which are in our possession. And my lord, if there is any doubt with regard to the genuineness of that, correctness of that, my lord, we call upon the arbitrator to produce his own record. I say that forget about the arbitrator. You say that you have been the respondent. The statement of claim was filed by me. Counter statement was filed by you. Matter was fought out. Meetings were held. 3 days of hearing. My lord, this somebody must have filed, my lord, the power of attorney for the purpose of appearing. Somebody must have appeared. Who appeared? Who produced by the legal documents? Citation. Look, this is surprising, my lord. Nothing came out from them. And they say, my lord, there is an award. My learned friend is alleging against us that wishy-washy statement with regard to fraud. I say, you forget about me. I have not been able to produce any document for the purpose of establishing fraud beyond reasonable doubt. I shall come to that issue. Nothing has been produced by them. After this, if your lordship is not persuaded to hold that there could not have been an award, because there is no document produced, no record produced, nothing is there before the court, then, my lord, how can, in addition to this, whatever we have relied upon to show that if the award had been made, any letter written subsequent to that would have mentioned that, look, these two contracts have stood completely settled. How? Because the awards have been passed in which there had been nil award against you. Therefore, what are you claiming? That's the first thing one should say. And I have shown documents, my lord, after the award has been passed, where, my lord, they are admitting that the account is still there. Account is still pending.
Reconciliation, as you said.
Reconciliation. Well, here I say that, therefore, this issue of verification, I shall show your lordship the paragraph in which very honest petition had been filed in my very respectful submission. What had been said to be true to knowledge is with regard to the proceedings which have been initiated, on the basis of which, my lord, the NCLC proceedings have gone on, and thereafter, my lord, change of management. I am not going to go into, my lord, the decision of Salomon and Salomon. Who doesn't know that the company is a juristic person and is separate, independent of the shareholders and the management? I am not going to contest that proposition. That is the correct proposition. What I am saying is this: today you are trying to foist some liability upon me on the basis of certain purported awards. I am saying that I am not going to accept any liability thereunder unless you can show that there was an award. And this challenge you have not been able to meet. You have failed to meet that particular challenge, particularly because you have completely failed to produce any record concerning this. Any record with regard to arbitral proceedings, either from the arbitrator or from yourself, from your own record. This my lord, enigma, I have not been able to solve. Every moment, my lord, I had told my learned junior that I am accepting this particular brief. But this is a very serious allegation is being made against the arbitrator, which I am not used to doing. And every moment I was expecting something should come from them. Nothing came. And now my learned friend is saying, you have not proved fraud. No particulars of fraud is there. Verification is not there. What verification? I have made the application. I am saying that this award does not exist. The onus is completely thrown upon you to sustain the award. Produce the documents, whatever is required. You did not produce it. And now you're going into the nitty-gritty of the particulars of fraud. But did they receive the original award? My lord, that has not been told to your lordship. As yet, my lord, I was expectantly waiting for them to say that I have received a copy of the award. Here is the award. Did they receive? They did not. Where did they get this copy from? Because, my lord, the entirety of the your lordship kindly sees the award. My lord, kindly come to the award once. This is very interesting. Kindly see the award at page 311.
Award. ওটা আলাদা করে ছিল বলটা কি এটি আছে
In the first volume.
ফার্স্ট কলম লাস্ট কলম
Lordship sees, my lord, the last page of the award. The 529, page 311.
আচ্ছা
Paragraph 11. In volume 3 one, it is volume 3 1 2. Oh, acha.
yes
Well, kindly see the award, the last page of the award, paragraph 11. In view of the findings on the above issues, the claimant is not entitled to any of the claims as claimed in the petition. In view of the foregoing, I render the following award. All claims of the claimant are disallowed and dismissed, and the parties are left to bear their own cost. It is not that the cost will be borne and paid by. Then, my lord, if that is so, then I ask this question. How is it that the arbitrator is saying at 347?
yes understood
That according to the fourth schedule, this amount 6,41,000 is to be paid by me. Kindly come to the second award. The claim amount is 60 lakhs at page 347. And this is exactly, my lord, in terms of schedule 4. This is amount, my lord, the total amount 2,71,875 at page 347 in the very same volume. So, my lord, they did not pay any fees. Then how did they get the copy of the award? If they did get a copy. This in the second award.
My learned friend will not mind the interruption. Where's the pleading that I did not pay fees and I don't have?
No, because you have not produced the award.
There is no.
Where is the award?
no Mr. Mitra is suggesting that as per the fourth schedule X will be the
I've
amount
understood.
and then
I've understood. This is again
obviously the
all in the air.
Pleading,
Where is it? There in his petition or his opposition or reply or whatever? Nothing. This is again what I'm throwing it out.
maybe this was your share meant by the arbitrator. Whether the claim is honest or not, we are not going into that. But are pending from your client.
Yes. If
From your client, your share of arbitrator
if
fee.
it is my share, then, my lord, it's not schedule 4.
No,
Schedule 4, according to the schedule 4, this is the total amount remuneration she is
the claim may be dishonest, but that does not vitiate the award. That is what.
No, but then again, my lord, the award is each party to pay and pay. I would expect, my
Yes,
lord.
the award is that.
Yes.
It may be very well be that the award has been passed, each party to bear his cost. This claim is dishonest subsequently.
Then, my lord, at
Maybe.
least, my lord, in the award it should have been that the cost will be borne and paid by the party who did not get the cost.
No, up to the award, it was correct. That may very well be. I mean, hypothetically, the award was passed, rightly, or wrongly, whatever. There is an award, but subsequently, when this claim is made, maybe the arbitrator claimed more than her dues. That may also be. And this does not retrospectively vitiate the award.
I tell you, lordship, why this suspicion in my mind. Because, well, they did not produce a copy of the award. The
That
award
remains. The other argument remains.
And the receipt of the arbitrator from the arbitrator.
So they have not produced anything, in fact, apart from that
Nothing.
copy of the award annexed to their reply before the NCLT.
Nothing else is there.
Nothing.
Nothing else. It's particularly when the challenge has been
Challenge has
thrown. I shall show to your lordship in the petition, because I have to take your lordship to paragraph in the petition in which, my lord, I have said that I did not know what are there. After there has been a change of management, we have taken over, and from the records I find this. When I say from the records I find this, if, my lord, the records would have contained something more, then was it not an onus upon my learned friends' clients to produce the copies of the documents, copies of which should be with me also?
So that there is a published award.
It is not only award. What I am saying is this: not only the copy of the award was not there, the copies of the proceedings were not there also. Then on what basis your lordship will be invited to, my lord, sustain the award? By just looking at a document which is sought to be an award, when, my lord, the original is also not there.
Difficulty is, Mr. Mitra, there is no specific provision in 34 to declare that an award is non-existent. There is no award. But if we say civil court, then you have to go to the civil court. That will be counterintuitive, because that goes against the grain of the Arbitration and Conciliation Act.
Well, my submission is this: I have prayed for, my lord, setting aside of the award. I say that there is no award, therefore award.
Otherwise, the normal law ordinary law should prevail. Ideally, there should be a suit for declaration that there is no such document.
That is,
because that is not there in section 34 specifically. That ground.
No,
that will be against, as I said,
completely against, my lord, the grain of the Arbitration Act. Arbitration proceedings is for the purpose of bringing about a finality in the domestic forum, the dispute between the parties.
Yes.
Now, if that is frustrated, then there is no point. What is being said here is this: that on the basis of this totality of facts, there could not have been an award. Therefore, kindly set aside what is sought to be produced before your lordship as an award.
Mr. Mitra, if you succeed in this application, under which clause of section 34 would you fall?
I will tell you, lordship. Lordship will kindly take.
Morality or justice may come in. Basic notions of morality or justice may come in. Fraud, if you say yes. The making of the award was induced by or affected by fraud. Yes, there is no award, you are saying.
Yes. My lord, kindly keep this open, and, my lord, your lordship will take the application which I have made.
Yes.
No, from the section, I mean, which provision?
Yes.
34.
Yeah.
34
Yes.
B, this
My lord,
expression, Roman 3.
No, my lord, I'm giving you, lordship.
Basic notions of
The section,
justice.
section 2, section 34, 2, B,
Explanation 1, Roman 3.
explanation 1.
Or public policy, if you call.
Yes, quite.
But public policy has been defined.
And, well, no, 1I also. Explanation 1I. The making of the award was induced or affected by
There's a distinction. This is, you said there is no award. No award cannot come within I. Ideally. The making of the award was induced or affected by fraud. If there is no award,
this is your lordship.
We have to read it into this.
Yes, yes. Then, my lord, I have to accept the award and say that it is.
No, morality or justice is there. Basic notions of morality or justice. But yes, at the end of the day, you are right, because this entire provision starts with against an arbitral award. So the presumption is there is an award. So therefore, there is no provision in this act which gives the court the power to declare that there was no award passed at all. We have to read something into section 34. There is no other provision.
An arbitral award arising from the arbitration other than intention
section
may
34,
also be set aside.
as per the language, cannot give a declaration that there is no award.
Strictly speaking, my lord, strictly speaking.
We'll have to read that into somewhere.
Yes. Setting aside means, my lord, an award is there and that is to be set aside. I quite appreciate that. But in a situation like this, my lord.
It was a very bad analogy. In a matrimonial suit, divorce suit can be filed before a district judge. But before the learned civil judge junior division, we can file a suit saying there was no marriage at all. So there's a distinction between the two. It does not come within the purview of the matrimonial laws at all then. It's a civil suit under section 9.
But to what extent, my lord, I will be able to...
to what extent I'll be able to say that, because it will be struck down in a second.
Yes.
Being contrary to the grain of arbitration. We'll think about it.
There is a judgment on this. There is a judgment.
If you can find it out in the...
I'll give your lordship the name.
We'll come back.
Mr. Both will know that I'm not there after 2. I'll tell you, Lordship, he'll come back. But Justice Shonji Banerjee, Ganges construction or something.
Judgments are gone because
That's
So resort to AI and find out the judgment and give it to me.
because
I
of
think it was Ganges.
I told you, Lordship,
Or Ganga.
Yes.
Ganga's-
these
Ganga
things have
probably
gone
Ganges.
because of this
It was against
statutory,
one
and
of
you
the high
say
purchase
from the
contracts.
framework of the Act, you have to proceed under the Act and all these judgments.
Because the language of 5 is no judicial intervention.
Yes.
But that exception made is in the case of fraud, which is
But
what
no
is right.
judicial intervention to what?
Yes.
But the exception is fraud, which is there in a few judgments. Not it's there. But in Justice Shonji Banerjee's matter, who you appear করেছিস? হ্যাঁ, you were appearing for.
But we lost the matter because of Justice Altaf Alam Shah.
No, we'll have to read that into section 34. We will do that. So we'll continue after 2.
Yes. Number 1 to 4 to continue.
Well, a lot of things have been said in argument with regard to the verification, etc. Well, I will request your lordship, my lord, to look at 529 I am on. Paragraph 3 kindly come to. Not paragraph 3.
Yeah.
Paragraph 6 and 7.
Yes.
I have said about, my lord, this NCLT proceedings. Paragraph 6 is the monitoring committee, after the approval of the resolution plan, has now handed over the said documents to the new management and the board of the petitioner. The new management of the petitioner, after making necessary searches, came to learn the mentioned facts. Then, my lord, respondent approached the petitioner. My lord, this is with regard to the documents which are admittedly on record. Then, my lord, paragraph 8, 9, these are all matters of record, and I have said so in the verification. And, my lord, paragraph 10, 11, 12, these are all verified as information derived from record. Then, my lord, your lordship will be pleased to come to paragraph. So, my lord, this is very truthfully affirmed. Very truthfully affirmed. Whatever was obtained from the record, that has been said. Because as I told your lordship, my lord, that this at that point of time, the resolution process was on, and the new management had come into existence who did not have any knowledge or notice of what had transpired. Well, here, the issue of the company being a jurisdictional entity, and, my lord, it is different from the individual shareholders and individual boards of management. But these issues, these questions do not arise. That is an admitted fact. But the person who is verifying the affidavit, he is saying that I came to know of it from the records. And whatever he had come to know from the records, he has said in these paragraphs, and these have been verified as information derived from records and believed by me to be true. But, my lord, kindly come to the grounds. The grounds, my lord, that is in paragraph 47, and rightly paragraph 47, which are the grounds. These have to be, my lord, by way of a submission, because the person who is verifying the affidavit, my lord, he is a novice, a client, and these are, my lord, the grounds which have been made by the lawyers. So, my lord, it has been framed in the form of submission. And kindly see, my lord, ground. Kindly come to ground V 5.
Yes.
For that, the impugned award dated 17 September clearly goes to show that the alleged arbitration proceedings were held during COVID pandemic period, which smacks malafide on the part of the respondent for obtaining the impugned award by fraud and by unilateral appointment of the learned sole arbitrator. And as such, the impugned award is perverse, patently illegal, opposed to public policy of India, and is liable to be set aside. So the ground is there. Then, my lord, kindly come to the next one. For that, the impugned award dated 17 September 2020 has been passed by the learned sole arbitrator without considering the fact that the petitioner had never made any reference, either by a letter dated 29 December 2019 or by any other letter to the learned sole arbitrator. And as such, the impugned award is against fundamental laws of India, patently illegal, perverse, opposed to public policy of India, and is liable to be set aside. In fact, my lord, I find that all the grounds in section 34(2)(a) and, my lord, small a, they have been set out here. Then, my lord, 7 also the same thing, that petitioner till date has not received any notice under section 21 of the Act referring the dispute to between the parties under the said agreement number so and so to arbitration, and then petitioner till date has not issued any notice under section 21 of the said act referring the disputes to arbitration. Then, my lord, I take your lordship to 9, ground 9. Further, the impugned award is in conflict with the most basic notions of morality and justice, as the same has been passed after unilateral appointment of the learned arbitrator by the respondent behind the back of the petitioner. Then, my lord, 11. For that, the impugned award was affected by fraud, corruption, and such liability. Now, Lord, I pause here for a moment. These grounds are there, and there are various other grounds also. Ground 12, my learned junior asked me to place before lordship.
Yes, I've read that. Right?
Unilateral appointment,
Unilateral
etc. My lord, I was just looking into the section. But বইগুলো কোথায় গেল? arbitration একটা মনে আছে। Lordship will please to take my lord section. I was just when these submissions were made by Mr. Bachag, I was looking into it. I feel, my lord, these judgments which have been cited by my learned friend, and I'm dealing with this judgment in this way. It seems, my lord, that this particular provision, section 34, after amendment in 2016, has, my lord, made a departure from our usual notion with regard to the pleading of the allegation of fraud. My lord, allegation of fraud, my lord, when it is made, it is generally in a suit, or, my lord, even in Article 226 application, fraud is alleged. But, my lord, the allegation comes from the party, the person who has suffered by the fraud. He comes to the court and brings it to the notice of the court that, look, these are the things which had happened, which clearly smacks of fraud. Therefore, you deal with it accordingly. This is wholly within the purview of the party concerned. That is why the court says that suspicion can never be the substitute for proof. You will have to make concrete allegation, and then you will have to stand by it and support it by evidence. It seems, my lord, that the Arbitration Act has made a departure. And why it has made a departure, I was just looking into the reason for it. The reason is this, my lord, that already the evidence has gone in before the arbitrator. The adjudication has gone in as it would be in a civil court. If, my lord, the allegation of fraud is made in the statement or counter statement of facts, that would be dealt with by the arbitrator himself. Now, when it comes before the court under section 34, then the court is in season over the matter on the basis of the record, on the basis of the pleadings of the parties. Then the court, after all these things are there and one of the parties says that some fraud has been committed, then, my lord, it seems, in order for the purpose of, my lord, there is not going to be a sort of large, full-scale, my lord, hearing, full-scale trial. It is not contemplated that under the provisions of the Arbitration Act, there should be a full-scale trial. The state trial is not contemplated. So what the legislators say is this, that under the Arbitration Act, when matter comes under section 34, on the basis of all the facts which have been placed before the court, if the court comes to the conclusion that there is an element of fraud, then, my lord, that should be sustained in terms of these subsections. In other words, if I may say so with respect, it seems that I don't say that the onus was put upon the court, but the court had been empowered to infer fraud on the basis of the records which are made available to the court. And that is the difference between all these decisions cited in a suit or in a proceeding before a civil court or a criminal court, where, my lord, the onus is upon the party concerned. What is being said here is this: you cannot lightly take these kinds of allegation. The court should not lightly take this kind of an allegation. The court will have to be satisfied that the fraud has been committed. How do you do that? Allegations which are made with full particulars and then you will have to justify those full particulars at the time of the trial. This will not be open. This opportunity will not be open to the court. So the court, after everything has come on record, including the evidence of the parties, court can, my lord, come to the conclusion. Supposing the arbitrator comes to the finding that there is no fraud, but on the basis of the record, court comes to the finding that there has been a fraud, the court will be entitled to, my lord, to set aside the award on that ground. This is, my lord, my reading of the act. See, it seems, my lord, the act contemplates that kind of a situation. Now, my lord, kindly see, if your lord looks at, kindly note this, that explanation 1 of small b, that is also, my lord, of 2016 vintage. Explanation 1 has been added along with 2A, 2 capital A, and both in 2016. Previously, it used to be like this. The court finds that, it's a court finding, and the basic difference, my lord, which I made my submissions before earlier, that language is so clear. An arbitral award may be set aside by the court too. An arbitral award may be set aside by the court only if the party making the application establishes. Kindly see, the entire onus is upon the party. And with regard to what? Incapacity, 1, agreement is not valid, 2, party making the application was not given proper notice of appointment, all procedural. Arbitral award deals with a dispute not contemplated or not falling within the terms of submission, 4, and then the composition of the arbitral tribunal, arbitral procedure is not in accordance. If these are shown by the party in their application, establishing all this, then, my lord, section 34, subsection 2 will come into operation, and the court will be entitled to set aside the award. Now, subsection B, 2B, the court finds, this is, my lord, the provision where the finding of the court becomes relevant, that the subject matter of the dispute is not capable of settlement by arbitration, or the arbitral award is in conflict with the public policy of India. These were very broad, so to say, my lord, provisions which were there originally. In 2016, my lord, this explanation 1 was added, which, my lord, really, I should say, gives a wide scope for the court to look into the records, to come to the conclusion, come to a finding. The court finds, my lord, then explanation 1, the making of the award was induced or affected by fraud or corruption, or was in violation of section 75 or 81, or it is in contravention of the fundamental policy of Indian law, or it is in conflict with the most basic notions of morality or justice. So, my lord, if a party, after the award has been passed, makes an application making these allegations, then the court will be entitled to look into the records. And if the court comes to the finding that any of these provisions have been satisfied, then the court can suo motu proceed on that basis, provided this allegation is there on the record. I am submitting to your lordship, we have made these averments. I have made these averments in this my petition, saying that these are the grounds for challenging the award. And if your lordship finds that these averments are justified on the basis of the records which are produced by the parties, I will submit to your lordship that court will have the jurisdiction to, my lord, look into the award and set it aside if necessary. Similarly, my lord, is 2A. An award arising out of arbitration other than the international commercial arbitration also be set aside by the court if the court finds that the award is vitiated by patent illegality appearing on the face of the award, provided the award shall not be set aside merely on the ground of erroneous application of law or by misappreciation of evidence. So, my lord, here the court's power is being first is conferred in the operative portion of the section, and then, my lord, by way of a proviso, it is being restricted. You can do so, but do not set aside merely on the ground of erroneous application of law or by reappreciation of evidence. do not reopen the issue by reappreciation of evidence and then set it aside. But you can do so if you find on the face of the award there is fraud, or, my lord, there is induced by fraud or corruption, contravention of the fundamental policy of Indian law, and its conflict. My lord, I submit to your lordship that grounds have been taken that it is contrary to the fundamental policy of Indian law. Why is it so? Because I have not been given notice. I did not know ex parte an award, so-called award, had been passed, to which I was not a party. I did not know of this award. It has not been served upon me. I came to know of it earlier from the proceedings before the NCLT. In a situation like this, my lord, the court has been empowered to do this. So, my lord, all the decisions cited with regard to particulars of fraud by Mr. Bachawat, with the greatest of deference to him, my lord, I submit to your lordship, will not be applicable when, my lord, one is looking into, or, my lord, considering these sections. This is wholly, my lord, on the basis of the record of your lordship will be pleased to come to the conclusion, because already the evidence has come in. There is no possibility of, my lord, giving any further particulars or better particulars than that. I have come to the court. I say that there is no award. I did not participate in the award. I did not know that there was any award. Your lordship, on the basis of the record, comes to the conclusion there could not have been an award in view of the correspondence which has gone on between the parties pre-arbitration or post-arbitration. So, my lord, this is something, my lord, I respectfully submit. So, all these decisions with regard to particulars of fraud and all that, they have been cited by my learned friend. I deal with them in one sentence, that after the promulgation of Section 34 by way of amendment in 2016, this concept of giving particulars does not arise, because the court will be entitled to find out from this. So, on this, your lordship will please to take the judgment which had been placed. And, my lord, I just want to place only one paragraph from the judgment of the Delhi High Court, which has been sustained by the Supreme Court when it went to the Supreme Court. Yes, this is, my lord, Devas employees. No, please. Yes, lordship will please to take one. My lord, kindly come to paragraph 108. This is, my lord, quoting from Sal Udyog. That we have cited before, lordship. I'm not again going back to it. Kindly come to, and Sal Udyog in turn had quoted, my lord, Hindustan Steel, Hindustan Construction, which I have also placed before lordship. And kindly come to paragraph 25, quoted from Sal Udyog in paragraph 108.
Yes.
Reliance placed by the learned counsel for the respondent company on the ruling in Hindustan Construction Limited is found to be misplaced. In the aforesaid case, the court was required to examine whether in an appeal preferred under Section 37 of the 1996 Act against an order refusing to set aside an award, permission could be granted to amend the memo of appeal to raise additional new grounds. Answering the said question, it was held that though an application for setting aside the arbitral award under Section 34 of the 1996 Act had to be moved within the time prescribed by the statute, it cannot be held that the incorporation of additional grounds by way of amendment in Section 34 petition would amount to filing a fresh application in all situations and circumstances, thereby barring any amendment, however material or relevant it may be, for the consideration of a court after expiry of the prescribed period of limitation. In fact, laying emphasis on the very expression, the court finds that, quote unquote, applied in Section 34(2)(b) of 1996 Act, it has been held that the said provision empowers the court to grant leave to amend Section 34 application if the circumstances of the case so warrants, and it is required in the interest of justice. This is what has been observed in the preceding paragraph with reference to Section 34(2)(a) of the 1996 Act. In both the above cases, the apex court had looked at the language of the provision under Section 34 of the Arbitration Act and laid emphasis upon the phrase "the court finds" that occurs in Section 34(2)(b) and 2(a) of the Arbitration Act. This phrase has been interpreted by the court as an enabling provision, allowing the court, while deciding an application under Section 34 of the Arbitration Act, to grant leave to amend an application under Section 34 of the Arbitration Act if the peculiar circumstance of the case so warrants, and it is so required in the interest of justice. The court has held that the phrase enables a Section 34 court to discover on its own, well, kindly note the language, discover on its own patent illegality in the award and set it aside under Section 34(2)(a). It has further held that the provision which enables a court to act on its own in deciding an application under Section 34 would also be available in an appeal under Section 37 of the Act. So, my lord, even at the stage of appeal, the court can look into it because the court has been empowered to do that. Then, my lord, para 110. The phrase "the court finds that," which finds mention in both Section 34(2)(b) and Section 34(2)(a), allows the court to look into the award and discover the grounds. Kindly note, language is very strong. Discover the grounds mentioned under Section 34(2)(a), 2b, and Section 34(2)(a) of the Arbitration Act. Consequentially, the phrase enables the court to discover suo motu whether an award is in conflict with the public policy of India. As a corollary, having regard to the explanation 1I of Section 34(2)(b) of the Arbitration Act, it follows that the court would also have the power to discover on its own whether the making of an award is induced or affected by fraud or corruption or is in violation of Section 75 or 81 of the Arbitration Act. We therefore find no merit in the submission of the appellant herein that Section 34 court does not have the power to suo motu discover grounds of public policy or fraud and set aside the arbitral award on that basis. Well, it's a very strong judgment, strongly written. But, my lord, what the court did was, the Delhi High Court, the division bench of the Delhi High Court did was that it interpreted the inserted provision which came into existence on the basis of the Law Commission report to give this power to the court, which was not available earlier, that on its own the court, on the basis of the record, can come to the conclusion or finding that there has been fraud or irregularity or any of the provisions of Section 2A, subsection 2, capital A, had been complied with. My lord, this is my submission before your lordship. This is a submission which I made. My lord, I am being emboldened to make this submission on the basis of latest Supreme Court and division bench of the Delhi High Court judgment. So, my lord, if my grounds are there, and if I bring records before your lordship, whether in the main petition or by way of supplementary affidavit, the fact that it was after, my lord, the period of limitation has expired will not matter. Because in the interest of justice, the court is entitled to look into it. In our instant case, my lord, there is no question of limitation. So, my lord, I really, my lord, this submission of mine, my lord, takes care of all the decisions cited by my learned friend with regard to verification, as also, my lord, with regard to the allegations of fraud. I submit to your lordship that now the facts are before your lordship. See, my lord, what has transpired. And contrary to these records which I produced before your lordship, they could not produce anything. This is what, my lord, I am on. I am submitting, my lord, that opportunity was given to the parties. Now, my lord, if I am seeking to sustain an award, which I say is a genuine award, and when a challenge is thrown that the award was not passed at all, then what should one do? The basic thing that one should do is to produce the records and say that, look, you participated in this. The minute says so. These are the minutes. Your presence has been recorded. This is the copy of the power of attorney, which you filed before the arbitrator. Copy was given to me. Here it is. But nothing is there. Nothing. And if the original award, signed copy of the award, that is section 31, subsection 5, has been served upon them, then the absolutely, what should I say, fundamental question would be that if you have got the copy of the award, then where is it? You produce it, simple thing. And so far the arbitrator is concerned, my lord, I do not know this. You pay the remuneration, and then I shall give. And my friend says that you have not given full particulars of the alleged fraud. Suspicion will not do. I say suspicion in a situation like that will do. Why will it do? During COVID period, when everybody was inside the house, you are holding the sittings in the middle of the COVID period. And you are expending money on transportation, on venue, hiring who was the stenographer who had taken down the award. Nothing, my lord, is on record. Nothing is being said. If this does not cause, my lord, an inference, I shouldn't say suspicion. I say now, my lord, we have crossed the limit of suspicion. Now, if one does not come to the conclusion on the basis of this absence of evidence from the side of the petitioner, or rather the respondent, then, my lord, I submit to your lordship, my lord, what stronger evidence can there be? A party is seeking to sustain an award. The other party is saying that there is no award. So is it not the onus shifting upon them to show that the award was there? And particularly when this gentleman had come subsequently, this Mr. Ki Rai? Adip Rai. Adip Rai, my lord, he was suffering from cancer. And after that, he had recovered. And then, my lord, he had affirmed an affidavit. And it is said that he was the man who was in charge of the arbitration. When he, my lord, filed the affidavit, could he not have, my lord, discovered or rather disclosed all the documents which were filed? Because he had been in charge of the arbitration. That's what he said in his affidavit. And he does not come forward with that. So what conclusion one? It is not what inference. What conclusion will the court come to? And the court having been given the power, entrusted with this power, I submit to your lordship, that is the end of the matter. In this regard, I will just take a few minutes. Yeah. Lordship, kindly give me 1 second.
Yes. The charge has not been cancelled throughout.
আমাকে
না তুই ওগুলো দেখে তুই আর
Lordship will please to come to in this connection. I will just give your lordship this document. After the reference, যখন I first wrote to them, yes, supplementary affidavit, পাতাটা দাও। Responding, this additional evidence, তাই তো?
না সেটা G1 এটা রেসপন্ডেন্ট ফাইল আমাকে সাপ্লিমেন্টারি অ্যাফিডেভিট এটা আমরা ইমিডিয়েটলি ফাইল করে আসলে চেঞ্জ করব। 5:30 তে চলে গেছে না। আচ্ছা
But will you please to come to kindly, my lord, page 107. My lord, these are supplementary to the 529. Supplementary দর্শক কাছে আছে। না 7 সেপ্টেম্বর না, তার আগে রয়েছে, তার আগে 1 মিনিট দাঁড়া। Lordship, will you please to come, my lord, to sorry, I'm sorry, I'm taking some time. চিঠিগুলো দেখিয়েছি, আমি উত্তরটা দেখাতে চাইছি। Lordship, will please to come to page 104 and 105. I've cited before Lordship this, but just by way of refreshing your Lordship's memory, my lord. Page 104. This is dated, my lord, 29 September 2022. 20th September, sorry, 20th September 2022. And here, your Lordship sees that this is after the award has been passed. We have said in that box, the contract number 138,524 and 130,853 have been mentioned, and against them, my lord, the amount due, that has also been mentioned. And then, my lord, at page 105, again, the outstanding position, the box starts with the words, please find the outstanding position of Messrs. Roadwings International as per ACFL book as on so and so. And my lord, there again, 130,853 and 138,524. These have been mentioned.
Fourth and the sixth entry.
Yes, fourth and the sixth entry in that box, there again mentioned. And then we are saying that since your statement under the said letter totally on afterthought and denied in toto, you are further request to clear the outstanding dues. Now, my lord, to that, they write, my lord, on 7th October 2022. This is a very crucial letter which clinches the issue. And, my lord, this is post-award. And there I have shown to your Lordship that Roadwings is writing, my lord, in reply to those letters. And it says that at page, my lord, next page, your Lordship will please to see
107.
at 108. Third paragraph, second paragraph is in respect of another contract.
Yes.
Third paragraph, in your letter dated 9/6/2021, you have earlier claimed an amount of rupees 1,51 lakhs so and so towards contract number 130,853. But on 20/10/2021, you have claimed an amount of rupees so and so. Copy of the letter is attached, which I showed to your Lordship. Then again, my lord, in the fifth paragraph,
Yes.
paragraph marked as 4, Roman 4, in your letter dated 9/6/2021, you have claimed an amount of rupees so and so against the contract number 138,524. But as on 20/10/2021, the figure has changed to 34 lakhs. Copy of the letter is attached, that I have shown to your Lordship. We have reconciled the account with your Vice President with a copy to the President, the then senior CEO, the then CEO, in the mail dated 28 to 2020. Copy of the said mail of Srey dated 28/2020 is attached Annex F, from which it reveals that your letter dated so and so is full of anomalies and an attempt has been made to put our company in distressing situation. Now I pause here for a moment, my lord. This letter, which has been mentioned of CEO email, which he has accepted as correct, because he has said that you have said this in your email, and that is dated, my lord, 28/2020. That is at page, my lord.
20 days before the award.
This is, my lord, 20 days before the award. This has been said. This has been sent. And I've shown to your lordship at page 120. This, in respect of these contracts, the amounts have been mentioned which are due and owing. And the total amount outstanding, that has also been mentioned. This has been accepted to be the correct. Then, my lord, how could on the date of the award, which is, my lord, 21st, this is dated 20th August 2020. Award was made on the 17th September 2020 and 21st September 2020. And there, my lord, if this is correct, then award cannot be correct. The so-called award.
And this has been acknowledged in the letter of 7th of October 2022.
And this has been, your lordship has been pleased to see that this has been acknowledged in
referred to in
page 109, 16 July 2022. No, sorry, 7th October 7th October 2022. One thing I don't understand, my lord, that these letters are there. No reply had been given. Kindly see page 119. This is in respect of, my lord, the contract number 138524, dated, yes, this is at page 119, dated 20th October 2021. After the award, this amount has been claimed. And then again, my lord, if your lordship comes to page 115, in respect of contract number 130853, and this is the present petition, 20th October 2021, amount of 92 lakhs has been claimed. How is it, my lord, that these amounts are being claimed and there is no mention of any award? And these are, my lord, all enclosure to the letter dated and reconciliation has been made on the basis of this. Kindly note, these are Annexure A at page 109, Annexure A, Annexure B. These are all mentioned in the letter at page 107.
Yes.
And these are letters of demand by me. And the reply is this. I say that what more evidence does your lordship need?
So this email was sent by them.
Yes, this letter of 7th October 2022
Mentions it, yes.
to the administrator it has
Yes,
been written.
Yes. Please find the final recon statement.
Yes,
appended.
and
that is reconciliation.
and reply to, my lord, this is a reply to all the annexures to this letter, which are at pages 107
Yes.
up to 107, 119.
Three equipment were returned. The value is 1,35,00,000. Where is the mention of 75 lakhs?
And this is they have accepted.
এটা কি লেখা রয়েছে পড়তে পারছেন?
কষ্ট আছে বলছেন।
Page 114, 115 and page 119.
120.
One more fact.
120, my lord.
I've shown
Yes,
you
114, I can read. Yes.
at the bottom. Your lordship can see that
Asset security.
Asset security, 3 rich stacker. Asset security, my lord.
Asset security, no, it's very clear. Three rich stacker.
1,35,00,000.
Yes, 1,35,00,000.
Where is mention of 75 lakhs?
So that's because, my lord, I'll just indicate, if your lordship sees at the top of the page,
Yes.
the date is given.
Yes. August 2020.
Exactly. That is
After
before.
After March 2020.
Before the award.
Before the award.
just before the award.
It is not
On
before.
7th March 2020.
So it's not that the reconciliation statement is post-award.
No, but you acknowledge that in your
I'm
subsequent.
saying, my lord, in the reply, if your lordship sees, it refers to annexure F.
No, you have argued
Yes,
that this was only reconciliation.
Yes, that is all. I'll put it in my notes, my lord. The explanations, they're going to be there in the note.
Oh, I just put this in the form of a question that if there were
Factual answer, I'll give it in the note. I will not.
this is a factual issue which I am raising.
Yes.
I'm saying that if there had been an award on 17th September and 21st September 2021, then why should you write a letter on, my lord, 7th October 2022 saying that there has been a reconciliation and annex page 120?
Award notes. Award notes that this asset has been surrendered on 7th March 2020. So if reconciliation is being done in August, where is 75 lakhs being recorded here?
Yes, my learned friend is right. Your lordship has heard it.
Said into the mic.
Clear, absolutely. In his exposition. Just শুনেছেন।
So at the end of the day, this reply is it much post award, 2 years after the award.
2 years.
When they say that previously you have reconciled
Yes.
and they stick to that amount to be the reconciled amount,
Yes.
even after the award.
Even after the award. আচ্ছা আমি আরেকটা জিনিস দেখাতে চাই in this connected petition আমি ওইটা দেখাতে চাই
reply to her demand notice.
Your lordship kindly stay সেটা আমি দেখাতে চাই
247 is আমাদের
kindly come to page 247 of the petition. This is the other thing that I wanted to show to your lordship.
এটাতে ওরা কোনো কিছু বলেনি এই ব্যাপারটা। In their opposition, we have not denied it.
Your lordship kindly come to just by way of reminding your lordship, kindly come to page 244. Page 244. Note the date, 30th January 2023. I am saying in the third paragraph of that letter, Shrey is writing, upon assessment of your aforesaid account, it has been observed that your account are in default, and in spite of several requests made by us, you have deliberately failed and or neglected to discharge your liability as agreed upon under the aforesaid agreement. As a result of such default, a total sum of rupees 11 crores and odd is due and payable, etc. Annexure A. Now, will you kindly see Annexure A at page 246. 130, item number 5, 130853. Amount pension is 1,28 lakhs. No, sorry, 3,68 lakhs. And item 6, 138524. Amount mentioned is 1,28 lakhs. Then, my lord, after that, no reply was given. So on 30th August 2023, that means 6 months thereafter, the advocate on record, my lord, of the petitioner respondent, my lord, wrote a letter demanding that amount of money. That is at page 247, 248. And kindly see page 250, their reply.
এটা অধীর কুমার রায় সাইন করেছে যার যে নাকি helm of affairs ছিল arbitration
Your lordship sees, my lord, dated 4th September 2023, reply.
post award.
Yes.
Post award, and my lord, signed by that gentleman who was suffering cancer. That is before, my lord, he was afflicted with this disease. And he is writing, my lord, kindly see first, second, third paragraph. Our duly audited account shows that all liabilities have been paid in full and nothing is left to be paid towards any of the agreement contracts to your client. However, to ascertain the contents of your letter, we would request your client to provide us with the following: copy of so-and-so, multiple contracts, communication, GST paid, so-and-so, etc. And on receipt of the above information and documents, we shall examine the same for necessary action and detailed reply to your good sir.
Apparently, they also had a change of management.
My lord. Yes.
They also had a change of management.
Absolutely. Unless, my lord, my learned friend's client was suffering from amnesia at that particular point of time, my lord, this letter could not have been written. If, my lord, there had been an award in respect of 2 contracts,
Yes.
the simplest thing would have been, so what are you talking about? Already the 2 awards have been by, nothing is due on payable. Now he is asking for this. There is not a whisper about the award. I am only on this issue. I am not on the, I may be right so far as accounting is concerned. My learned friend's client may be right so far as he is concerned. But that is not the question. Question is that award exists or award doesn't exist. That is the only issue before your lordship. And my submission is this.
And the other question is to be or not to be.
Had to be or not to be.
Yes.
Therefore, my
So
lord,
they have never mentioned about the award also. That is your.
so therefore, my lord, on the basis of this, which has now come before your lordship, my lord, until the hearing is taking place, there is nothing else is there from which your lordship can come to the conclusion that an award had been made. And again, my lord, I repeat, if an award had been made, where is it? I will request your lord, my learned friend to produce that award. If he has received, my lord, a signed copy of the award, of which, my lord, he is clamoring about, then where is it, my lord? Am I not entitled to ask him that question? Issue.
Mr. Bose is also asking you a question. First handle him, then come to us.
তুমি তো ভয় পাও কেন আমি বুঝি না এত ভয় পেলে চলে না
His estimate of the judge. That's nothing to do with your. Never sure what may, anything may happen. Whether it penetrated or
মানে really I don't have anything আমাদের আর
that's
কিছু
qualified. Heavily loaded.
আমরা নোট করে দেবো আর কিছু my lord, I really I don't
No, really, you have argued this.
yes, my lord. And my submission is this, that so far as these decisions are concerned, I'm not wasting your lordship's time by taking individually. So far as verification is concerned, as I submitted to your lordship,
Honest.
verification has been very honestly made in the petition. Those which are information derived from records, he has said so. Those which are to his knowledge, he has said so. From the what has been derived from information from records, they have been produced before your lordship. Now, my lord, section 34, 2 capital A and 2 capital 2 small b, they come into operation. And my lord, the court is, my lord, invited to look into the records produced by the parties in support of the grounds which have been made, and requesting the court to come to the conclusion, can there be an award if this is the correct thing? If your lordship comes to the conclusion that there cannot be any award, it doesn't make any difference how I verify it, because it is the court which is to, my lord, to come to the conclusion. Well, as I submitted to your lordship, my lord, in the opening, I say that this has, my lord, made a departure from the usual law that is applied in usual procedure with regard to giving particulars and giving evidence.
Or a 6-4 does not have.
Their suspicion can never be a substitute for proof. I concede to that. But I say that Arbitration and Conciliation Act, by way of amendment in 2016, had brought about a sea change in the concept of fraud. Because, my lord, I suppose, I think, my lord, this is perhaps maybe some amount of guesswork on my part. After noticing, my lord, the working of the Arbitration Act in the meantime, after all, it's a private forum. Most probably, this kind of allegations came up more than once. So, my lord, at the stage of section 34 application, at the stage of section 37 appeal, my lord, courts will have no opportunity of looking into the facts in the sense, my lord, examining a witness for the purpose of finding out if there is a fraud or not fraud. So, my lord, the legislator has given the power to the court that you will be entitled to look into the records produced by the parties at the time of hearing. And you can suo motu come to your own conclusion as to whether there is fraud or not. And that is the, my lord, change that has come about. So, my lord, all these submissions which have been made with regard to the full particulars to be given, it is how to be verified, this becomes immaterial. Once, my lord, the materials come before your lordship. Well, these are my respectful submission, unless, of course, there is any question your lordship wants to put me.
notes file করে দেবো স্যার
Yes, official file a short note, my lord.
Yes. So when should I keep it for that next no Friday only, because I see
Not-
Stingly on Friday.
না না তুমি ফ্রাইডেতে এসো না, তাড়া করছো কেন তুমি? জজ সাহেব বলছেন ফ্রাইডেতে
No, Friday.
তাতে কি
No, because Mr. Mitra, I could have asked you to file a written notes with my officers, but since this is not a regular bench, so
lordship?
it may be misplaced.
Yep.
Many things may happen. So
I'll
better
wait.
to file it in open court so that they can
Yes,
put it in the
quite
record and
right.
hand
So
it over.
both parties can
It
also.
will be difficult for them also.
তোমার কি বলবার আছে?
Hearing is concluded. Full learned counsel for the parties are requested to file their respective written notes of arguments on February 27, 2026, when the matter shall next be listed under the heading to be mentioned. To mention.
May I just indicate one fact?
Yes.
Look, page 247, which is Mr. Kanodia's letter, it refers to other agreements. So the reply to that wouldn't have referred to the contract where the award has been passed.
No, it is in reply to the letter which.
Yes, that
tabulates
correct,
that.
correct. August 3rd. And the reply is to August 3rd. I'll put in the factual aspect. To wrap it up, my lord, the defense is as good as the petition.
But I must frankly confess, my lord, I congratulate my learned friends for the bold argument that they have made, in spite of the fact that no record.
It's the part of his argument.
It's part of his
Very mistake,
argument. It's a part of his argument, definitely.
All for formally here.
Great.
Five, we can barely start, Mr. Shen, because 7 minutes.
But for our purpose, it will be
Sufficient.
sufficient.
7 minutes is fine.
5 and 6. Oh, 8. I'm sorry. I'm the respondent. I had made my submission on one day, if your lordship recalls, regarding
Yes.
claim number 1 and 3. That is the extinction of price and, my lord, on account of repairs. And I had tried to show, my lord, that the arbitral tribunal had also proceeded on the principle of section 59 of the Sale of Goods Act. So, my lord, if there are conclusion is arrived at by the tribunal taking two grounds. One, if there is no flaw with one. Regarding the other, lordship entertains a doubt. But based on the first ground, the conclusion is arrived at on the basis of the first ground, which is a legitimate ground in terms of Sale of Goods Act. So the ultimate decision may not be vitiated only because another ground which is also taken may not ascribe to the view of the court. That, my lord, I had tried to submit, because first the entire discussion has been made on why 59 should apply. And if 59 applies, then extinction of price is under section 59. And in addition to extinction, you can also claim damages. That is 59 too. So going by 59, he has looked into the other claims, which is in the nature of damages. Claim number 3 and claim number 4. Claim number 3 I had submitted. Claim number 4 was left, my lord. I think your lordship was seeing it from the 36 briefly award. GA1.
G1 যেখানে ট্যাগগুলো লেখানো আছে ওটাই obviously ওটাই ফলো করছে yes
Well, today I will start from Your Lordship takes in it 102 of the award,
Yes.
majority award. Last page of 100 and last para of 102.
ये I got order sheet টাও দেবে তোমার? Yes, 102.
It starts with there is a major claim made by the claimant in this proceeding.
So then we are on the wrong.
এই তোমাদের পেজ নাম্বারটা একটু বলো।
This is G1 of.
Yes, well, 102 bottom. But what is, I'm sorry, Malad, this is the internal page I'm saying.
Yes, internal. Oh,
Yes,
I see.
internal page.
Very good. There is a major.
Yes. No, no, this is original page. This is original page.
Appellate side is from 3 p.m. Yes.
Says, well, there is a major claim made by the claimant in this proceeding that is on account of increased cost of electrical energy and extra expenditure. This claim has been narrated in para 48 of the statement of claim, detailed evidence given by the claimant's witness in para 55. The claim according to the claimant has arisen by reason of the failure of the turbine to perform, which prevented the claimant to utilize the captive power plant till the new turbine was installed, which resulted in loss and sufferance of damages. In order to prevent sufferance of high electricity and fuel charges, the instant contract was entered into to purchase the TG set. TG set, which was supplied by the respondent, did not perform. Claimant could not get benefit of the set, consequently went on incurring electrical energy for a higher amount. The schedule containing the details of the increased cost has been produced by the claimant, exhibited at Exhibit 107. Claimant has also produced the bills raised by DVC from whom the claimant used to get the electrical energy as Exhibit 114. Calculating in details about the extra energy of high safety oil has been disclosed in the statement of claim. So, well, this is my claim because my generator did not work. I could not run my captive power plant. Therefore, I have continued to use electrical energy from the DVC. That is the higher amount of the bills which I have exhibited. Secondly, that was also not sufficient. So I had to hire the generator set. So this is the loss which I have calculated till the new turbine was installed, which I could have avoided had there been a compliance of the condition of the sale. So these are the grounds, these are the two documents which I have exhibited. What are the bills of DVC? On the basis of the bills of DVC, I am calculating the higher charges for electricity consumption and the bills for diesel generators.
Mr. Shen, one
Yes.
argument was made by the other side, Mr. Chindra, probably that if you had this generator set functioning properly, then it would cater to a part of your needs. Even over and above that, you would have to take electricity from the DVC, right? Am I right on that?
I would have to consume only the minimum contract demand. Here, what is happening? I am consuming over and above the minimum contract demand.
Very good.
So the difference between the minimum contract demand charge and the charges for amount of per unit consumption of electricity, that is my loss.
So you have calculated it in that manner.
Yes. Plus the diesel generator set, that's a separate aspect. So it is not that I am claiming the entire amount of the DVC bills.
Yes, that was in my mind. I mean, I was
Bill
confused on that. Yes.
Bill amount value minus the minimum contract demand charge. The claimant has also referred to the document being the ledger showing the expenses incurred on such account being Exhibit 115. Claimant's case is that high expenditure on account of electrical energy could be reduced only after installation of new machine after 8 June 2010 from 9.43 plus per kilowatt hour to 2.57 per kilowatt hour. The evidence in this regard of CW1 and CW2 was placed. It is evident from the record that no cross-examination was made by the respondent on this document. According to the claimant, that claim of damages on this account was directly a result of the failure of the respondent's turbine. Against this claim, the claimant respondent's contention was that annexing DVC bills and the ledger account are meaningless Respondent's contention was that the claimant had not proved the said claim of 7.56 CR. According to the respondent, there is no proof of payment to DVC as allegedly made by the claimant. But if there is no payment, I cannot show continuous consumption. That is number one, my lord. And here, well, DVC bills is a primary document. So, my lord, suppose, my lord, that document is not disputed, then I am not required to further prove that document.
So, Shen will take it up from the
Yes,
here from the
we
next,
shall
on the next
continue.
because third in part list the matter for further hearing on February 27, 2026.
All right.
This will be the first matter.
Yes,
Yes.
I will have to reach by 10:29. Obliged.
Thank you. Oh, what's this?
Item number 6. Item number 1.
I am for the alleged contempt, my lord. My lord, pursuant to your lordship's directions, my lord, we issued this.
What is the alleged contempt, Mr. Maitri?
Lord, the lordship's passed an order, my lord, they kindly appreciate. Order dated, my lord. Order dated, my lord, January 6, 2020. And the inner page, last bottom portion, my lord, inner page 3 of the order, directing the respond number 7 to implement the order dated such and such. This is how which is annexed P4 to the page 25 of the instant deed petition immediately. This is the order.
Where is that order? By which was to be complied with?
Well, the respond number 7. Respond number 7 is the mind of the officer in charge.
Where is that order which was to be complied with? 31st of October.
Page 48 of your lordship's bill. Well, that is, my lord, the page 25 in the read application. And your lordship,
Speaking about the REIT application, we are speaking at the
our lordship's 40,
yes, I found it. Thanks to Mr.
48 condemn.
And the contemner is the
Officer in charge.
officer in charge.
And this order was also communicated to
Yes,
the,
Mr. Samud, why
My
not?
lord, after that, my lord, we went to the office of the Cooperative Society. Nobody was there. We pasted the form notice, and FIR was GD was there. Thereafter, subsequently notice under 188. FIR was there. They have been charge sheeted also, my lord. But we cannot vacate them, my lord. Kindly direct us to remove them from there unless, my lord, there is a specific direction, my lord. We are unable to do so. My lord, kindly
What?
But they are occupying this cooperative society persons are occupying the portions of the land, my lord. We have issued notice. We have asked them, but still they have not vacated. But we have
So what sort of order did you want?
my lord,
You are a party. We should have said that at the time of passing of the order.
this is my fault.
You are a party.
My
here.
lord,
Not that you are not a party.
we are not. We are the party, my lord. We are the party.
So what specific order is required? We directed you to
remove-
implement the order. The order says to vacate such and such.
My lord, may I humbly request, my lord, kindly ask the alleged contempt not to take action to remove them from there, my lord. Unless, my lord,
Vacating means what?
vacating means that, my lord, unless, my lord,
No, this is not a defense in contempt.
no, I have not taken any defense, my lord. But kindly direct that, my lord. We will take every action as per your lordship's direction, my lord.
Why should you give a direction? We directed you to comply with this order, 31st of October 2017, which says you are hereby
Whenever we
directed
are
to.
going there, no persons is being found. That is the difficulty.
That is
So-
once time. The
No,
second.
my lord, we pasted the, my lord, my report says, my lord, we pasted the notice upon the office of the.
You should have vacated and whatever was there, remove, at least take an inventory and put a padlock
My
and
lord,
give it
my
to the
lord,
district
will,
magistrate,
we will, my lord. They are-
ADM.
ADM.
Learned counsel appearing for the alleged contemner files a report in the form of a communication. It is submitted that since there was no specific direction incorporated in the order of this court dated January 6, 2020 to remove the persons occupying the concerned plot and stroke or to break open the padlock installed thereon, comma, the alleged contemner went to the premises in question, but having found none there, comma, pasted a notice on the subject property. It is submitted that thereafter a first information report has been registered,
My lord.
uh,
Ended in a charge sheet.
which has culminated in a charge sheet.
My lord.
It is submitted that criminal proceeding also initiated.
My lord.
It is submitted that consequent to such FIR, comma, a criminal proceeding has also been initiated. So the next para, learned upon hearing learned counsel for the parties, comma, it transpires that by the order of this court dated January 6, 2020, comma, the alleged contemner had been directed to implement an order dated October 31, 2017, passed by the ADM and DL and LRO, comma, Barasat, comma, District North 24 Parganas, which was annexed to the writ petition in connection with which the said order was passed. So next para, by the said order, comma, the ADM and DL and LRO had directed the secretary, comma, Purvachal Cooperative Housing Society at village Hatiara Sardarpara, comma, P.O. Ghuni, comma, District North 24 Parganas to vacate 18 decibel of land used as Probhati Shishu Uddan, UDDAN. এটা পেজ 48 এ পাবে তুমি এই চিঠিটা। Of plot number 4366 of Mouza Hatiara, comma, JL number 14, immediately as the addressee was possessing the land in an unauthorized manner, as the subject land was a vested land settled in the form of patta with a beneficiary, comma, failing which action would be taken as per law. Next para, in order to implement the order of this court and that dated October 31, 2017 of the ADM and DL and LRO, comma, the alleged contemner is directed to use force if necessary, and upon breaking open the padlock, comma, or other hindrance, comma, if any, affixed to the premises in question, comma, take possession of the same and deliver the keys to be affixed thereto afresh to the concerned ADM and DL and LRO, comma, North 24 Parganas at Barasat, comma, along with a compliance report in respect of the order dated October 31, 2017. It is made clear that consequential action for taking such possession would also be permissible to be taken by the alleged contemner within the confines of law. Next para, it is expected that such procedure shall be undertaken and completed within a fortnight from date. Next para, the alleged contemner shall file a compliance report in that regard, comma, with an advance copy to the learned advocate for the petitioner, comma, on the returnable date. The matter shall next be listed under the same heading on March 13, 2026. You are given time till 6th of March, fortnight, and I am keeping it 1 week after so that you can give a copy to him. And
But the communication will be written with the record, my lord. The communication.
yes, the communication, the written instruction filed today is kept on record along with the affidavit of service filed by the petitioners. Next para, the parties hereto and all concerned shall act on the basis of the written communication of the learned advocates for the parties and stroke or a server copy of this order without insisting upon prior production of a certified copy of thereof for the purpose of compliance.
Well, one more thing, well, the alleged container has already transferred. The new income has joined. Well,
আচ্ছা যেখানে যেখানে alleged contemner বলেছি সেখানে সেখানে the new incumbent holding the post of the alleged contemner,
Mal.
namely give the name,
Soikot Banerjee.
namely শ্রী সৈকত ব্যানার্জি।
Mal.
প্রথমবারে নেমলি শ্রী সৈকত ব্যানার্জি, তারপরে শুধু ওই leave is granted to the learned advocate for the petitioner to incorporate the name of the present incumbent in place of the alleged contemner. Let's do this, do it during the course of
Here and now. Lord, the affidavit service kept with record.
stated.
Lord, the copy. Lord, may I have a copy of the copy?
No, no. That's between the contemner. So give the name again, the spelling of the name to your learned friend, the learned junior. Yes. None appears. By an order dated February 13, 2026, it was recorded that none appeared for the parties at the time of call, and a last chance was given to the petitioners to move the contempt application. Full stop, next para, even today, comma, at the time of call, comma, none appears for the parties. Accordingly, CPAN 319 of 2021 is dismissed for default without any orders to costs.
Item number 3.
My lords, I appear for the applicant, my lords.
Yes.
The order stands complied with, my lords.
Very good.
An order has been passed.
Right. Learned counsel for the petitioner, comma, on instructions, comma, submits that the order under contempt has been complied with in the meantime. Petitioner, in the meantime. Full stop, next para. Documents, copies of documents in that regard, comma, including a communication dated December 20, 2021, and the copy of an order dated December 20, 2021 is handed over in court. Full stop. You are for the petitioner?
I am for the petition.
Yes. In court today and kept on record. Full stop. Accordingly, comma, CPAN 976 of 2021 is disposed of as infractions. No orders to cost. Thank you. Thank you.
Number 4.
By an order dated, তন্ময় এর আগের অর্ডারটা মেঘনাদবাবুকে দিয়ে দিত, by an order dated February 13, ওই dismiss for default without an orders to cost. ওই আগের অর্ডার একটা রেফারেন্স আছে, তন্ময় যেটা নিয়েছে এর আগেরটা যেটা নিয়ে dismiss for default. CPN 16 of 2024.
Item number 5.
Appear, my lord, for the alleged contemner, they were supposed to file serve a supplementary affidavit. Terms the last order.
Yes, where is the supplementary?
Lordship, actually, my client instructed that there is a conversation by and between parties to settle the dispute, Lordship.
You are dismissing the contempt application, settle it between this.
No, Lordship. If settlement is not comes, then we will
When should
file
you keep it?
supplementary.
Let it go out of the list or what?
Yes.
How long will you take for settlement?
1 week time, Lordship.
We'll give you 2 weeks. Then counsel for the petitioner submits that a talk of settlement is going on.
Take instructions because
No, you are saved.
that's
You're not affected adversely.
no.
The supplementary, Lordship, they have filed a writ petition and the
Talk
writ
of settlement is
yes,
going
Lordship.
on between the parties. Full stop, next para. Accordingly, learned counsel for the petitioner seeks some time to explore the avenues of reconciliation. Full stop, next para. Accordingly, comma, on the prayer of the, you want to file that supplementary if it does not materialize?
Yes.
Accordingly, comma, on the prayer of learned counsel for the petitioner, the time for filing supplementary affidavit is extended for a fortnight from date. Full stop. The matter shall next be listed on March 6, 2026. Full stop. An advance copy of the supplementary affidavit shall be served on the learned advocate for the alleged container number 1 as per the direction dated February 6, 2026.
But instead of 6th of March, may it be the Friday after
13th, March, Friday the 13th.
Friday 13th, yes.
Yeah, and you are the container.
And I'm the contemner.
Grateful. Yes. Yes, Mr. Wadi. Oh, you're for the alleged contemner?
For the school authority, my lord.
You're the contemner. The school authority is the contemner.
Yes, my lord.
What is the alleged?
Consider as the DI. My lord,
DI. What is the alleged?
contempt application has become infractions. Perhaps, my lord, your lordship's direction was to
What is your instruction?
to allow the petitioner to resume his duty. That was done.
Acha.
Subsequently, your lordship granted liberty regarding the salary portion. Your lordship granted liberty to approach the rate court. They file an application for salary.
Read petition.
Yes, that order was granted behind the back of the school authority. We filed an application.
That is not a part of this order.
Yes, that is
So
not part of
therefore,
this order.
you are not in contempt of this. You are in
My
contempt
lord.
of some other order.
Yes.
Yes.
My lord, I'm led by Mr. Bhagat, and Mr. Bhagat is appearing in this contempt petition. He's out of station, and hence my instruction would be that
Please, ma'am, take instruction whether this order has been complied with in the meantime. Tell Mr. Bhagat to take instruction whether this order has been complied with, because that is the
contempt is infructuous, sir.
Pardon?
The contempt has become infructuous, and
This
the
is your
matter
first
not being
appearance.
raised. Yes, my lord.
No, you are doing very well. Yes, it has become infructuous. Why? Why do you see it has become infructuous?
That is the only instruction I've got from my senior.
Very well. Learned counsel for both the parties submit that the contempt application has been rendered infructuous in view of compliance of the parent order by the alleged contender. Full stop. Next para. Accordingly, CPN 444 of 2024 is disposed of as infructuous without any other cost. Thank you.
Thank you, my lord.
Please give your name only, or both of you, not Mr. Bhagat's name. He's not there on his ground here.
Item number 7.
Vishwaranjan Bhagateর নাম কিন্তু ঢুকবে না, out of station থাকলে risk হয়ে যাবে. This item 7. Item 7 ওই item 2 তে যেটা dismiss for default মেঘনাদু. না 13 দিয়ে হচ্ছে same, exact same order. ওই অর্ডারটা আরো কিছু হতে পারে, অনেক দিয়ে বলে দেবেন। আর তো দুটো আছে, আর কি করতে এসছো?
In item number 8, my lord, I am praying for time for extension of filing the affidavit of reply. And they have already supplied me the copy of the affidavit in
You're
opposition.
harassing the Deputy Solicitor General. How dare you? We won't extend time.
My lord, they
just
have
found out time to come to this court and you're disturbing it.
Kindly not embarrassing. It is always.
He's appearing clean shaven after a long time, and you're 1 week, Mr. Sinara.
at least 3 weeks is required.
What 3 weeks? No. Contempt application cannot be kept. Why?
2 weeks then 2 weeks.
Why?
My lord, I am searching one gazette notification. That's all, my lord.
You'll wait for that to be published.
No. It is already published, my lord. I'm just coming back, my lord, with that.
Ask him, he'll give it to you.
May I open
Gazette notification?
May I open my mouth for just 30 seconds, my lord? 30 seconds.
By the clock.
By the clock, my lord. My lord, my
Lord,
affidavit of opposition, we take it on record, my lord.
15 seconds gone.
And now 15 seconds, my lord. This is a contempt which they are, my lord. It is said that certain statements were made by us before this honorable court.
My lord, on that.
No, let him finish.
On that occasion.
It still has 10 seconds. Yes.
My lord, again it starts. So, my lord, they have alleged that we had made certain submissions before my lord, and then subsequently thereto we have filed an affidavit. Both were false. This is their
perjury in a sense.
That is their, but we have shown in our affidavit that it was already in CPP portal. The dispute is that we, the Port Trust, did not. This tender was not reflected in the CPP portal, and we said this was reflected in CPP portal. That is the subject matter of the main writ petition.
So, what will you do with the gazette notification, Mr.
My lord, in the.
No, my lord, after our affidavit, they are searching some more.
My lord, no, my lord, in the particular, there is actually. My lord, without any document, I cannot, my lord, make my submissions.
Don't fish out evidence.
My lord, I shall not fish out the evidence.
1 week at most. You cannot keep a person's this sword hanging on a person's head. Contempt, we cannot grant you 2 weeks time for a reply. Sorry. Either you file the reply within a week, or we'll take it up without.
30th January, we had served on them this affidavit.
Yes. Learned counsel for the petitioner seeks further extension of time to file affidavit in reply. Full stop. Accordingly, the time for filing affidavit in reply is extended for a week from date. Full stop. It is made clear that in the event the affidavit in reply is not filed on the returnable date, the matter shall be heard without such affidavit. Full stop. The affidavit in opposition filed today by the alleged contemners be kept on record. The matter shall next be listed on February 27, 2026. So, after line add an advance copy of the
my lord,
affidavit of the affidavit in reply shall be served on the learned advocate on record for the alleged contender. Yes, difficulty on that date.
My lord, I have been told, my lord, my leader in this matter, Mr. Abhijit Mitro, is in bereavement. His mother has, so my lord may keep it on 6th if my lord so deems it. So I've been just told.
Then we'll give them 2 weeks time.
Yes,
then I will give it 2 weeks time. Very well. তাহলে ওটা রিটার্নেবল ডেটটা 13 March 6, sorry, March 6, 2026 আর টাইমটা fortnight.
Grateful.
But this is the last chance, Mr. Senator.
Yes.
I'm grateful, ma'am.
Item number 9.
What application is this?
This is for the modification of order.
I'm for the writ petitioner. The application was served upon us, but then few documents which are very relevant for the application to be judged are not on record. I have to take time.
Will direct to file an opposition then.
Yes, and in the meantime, they were directed time to file their opposition in the writ petition, which they have till date not done.
My lord, it is ready.
Not served upon us.
The writ petition is not before.
Not before my lords.
Not before me. Not before me. I cannot take that.
Yes, Lord.
My lord, kindly.
We'll record your submission and their submission that is ready.
Yes, Lord. Yes.
My lord, regarding this modification, so far as this lease is concerned, the lease period is over. Only because there is a stay, we are not getting any money, and neither we are.
We'll give your learned friend a very short time to file this opposition. Only one.
My learned statement.
We only have to annex the documents. So we'll give you 1 week time.
Yes.
1 week.
My difficulty.
No, Miss Shah. No difficulty.
No, my difficulty is the petitioner is in Allahabad.
Let him be there.
He is doing business
there. Prepared that in the meantime by now. When did you get the copy?
The copy was served upon us in January.
No.
But yes, but it was not moved till this time. It was served upon us in January in 2025.
Maybe you should have taken instruction and prepared it.
Instructions here.
So if it is an opposition, should have been prepared in advance.
Till this time, the writ petition was not proceeded with.
No.
They have not taken the matter never came.
Yeah, we cannot wait for him to come from Allahabad. Come on.
Doing business here. He's running his stall, and railway authority is losing money every day.
The person has to affirm the affidavit.
For last 4 years, we are not getting a single penny, but he is doing his business here.
I can demonstrate here and now.
You have to wait for 3 weeks for
But in 2024, we have made payments.
Counsel for the respondents in the modification application seeks to use an affidavit in opposition to disclose further relevant papers. Accordingly, the respondents are directed to file their affidavit in opposition within a fortnight from date. Reply, if any, shall be filed within a week thereafter. The matter shall next be listed on March 13, 2026.
I'm deeply obliged. No, I will not take this now. Send me a communication.
Please give copies in advance,
Yes,
so that they can prepare. And
I will.
Otherwise, if you serve on the previous day, Ms. Shah will obviously say that she is not ready. Obviously.
But I will serve them in advance.
Please.